a.m. and we are ready to go and start the August 2025 meeting of the Tennessee Real Estate Commission. Our first order of business is the public disclaimer and roll call by Ms. Baker. Ms. Baker, please.
Thank you. Notice of the August meeting of the Tennessee Real Estate Commission, including date and time, has been noticed on the Tennessee Real Estate Commission website since September 15th, 2024. Additionally, this month's agenda has been posted on the website since Wednesday, Wednesday, July 30th, 2025, with an updated agenda that included a broker name change that was posted on August 4th, 2025. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the provided sign-in sheet or by placing their name in the chat box online. It is requested that comments be limited to 3 minutes out of respect for other speakers. I will now call the roll. Chair Diaz. Vice Chair Ferris. Commissioner Moffitt.
Here.
Commissioner Begley.
Here.
Commissioner Torbett.
Here.
Commissioner Gwynn.
Here.
Commissioner Smith.
Here.
Commissioner Tucker.
Here.
Commissioner Gahn. Chair Diaz, we have a quorum.
Thank you so much. Next item is the prayer and the pledge. I've asked Commissioner Torbett to lead us in both, please.
Dear Heavenly Father, thank you so much for the opportunity to be here today. I thank you for each one in this room. I ask that you bless our efforts today, help us to honor you in all that we say and do. Be with us as we travel home. In Jesus' name, amen. Now please stand for the pledge. I pledge allegiance
Thank you so much. Next is the adoption of the agenda. All commission members have been provided with the agenda for today's meeting. Are there any changes or amendments? Hearing none, is there a motion?
Move to approve.
Got a motion to approve the agenda by Commissioner Smith, seconded by Commissioner Tucker. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Next is the approval of the minutes from June's meeting. Commissioners, if there are any changes or amendments? Hearing none, is there a motion?
So moved.
I have a motion by Commissioner Smith to adopt the minutes from the June meeting, seconded by Commissioner Moffitt. All those in favor, please say aye.
Aye.
All those opposed? Hearing none, that motion carries unanimously. Ms. Baker, please call the roll for our informal appearances.
Good morning for those who are joining us via Teams for the informal appearance section of the TREC Commission meeting. I am going to call roll. Everyone that is here for informal appearances must have their principal broker present to be presented before the commission. So do we have Alyssa Nevitt? And principal broker?
Here. I'm here too.
Candidate B, Guy Hardaway, and principal broker Kenya Flemings.
Here.
Yes, I'm here.
Thank you. Candidate C is Kayla Fanat and principal broker Roger Sargent.
I'm here.
Present.
Thank you. Candidate D is Malika Roberts and principal broker Lynn Bird.
Here.
Here.
Thank you. And lastly, we have candidate E, Tabitha Cox with principal broker Will Cup.
I'm here.
Here.
All right, thank you so much. We will begin with informal appearances.
Thank you, Ms. Baker. So the order of how things are going to proceed here, we're going to start with candidate A. Ms. Nevitt will be able to give us a brief statement as to the circumstances that bring them before us today. Commissioners will then have an opportunity to ask questions of the candidate, and then the principal broker will be able to speak in support of the candidate. And then after that, commissioners will have another opportunity for questions. Once the questions have been exhausted, we will then entertain a motion to approve the candidate or not, whatever the vote results will be. and then you will be allowed to go on about your day or stay and listen to the rest of the meeting, however you want to do. With that understanding, the ground rules, Ms. Nevitt, please describe to the commission the circumstances that bring you here today.
One moment. May I give a brief summary for candidate A?
Correct. Ms. Baker, tell us about candidate A.
Thank you. Ms. Nevitt is before us today due to a theft and shoplifting charge. She has taken and passed her affiliate broker exams. Her statement and letter of recommendation can be found on your iPads.
Thank you. Ms. Nevitt.
Good morning. My name is Alyssa Nevitt, and I have passed both of my exams for real estate. I am a small business owner for the last 12 years. I specialize in the beauty community. I have opened multiple businesses and employed many people. I've been a leader for a long time. I've also been a managing director for a beauty school as well. I had a very rough upbringing as a younger child. I, I have been on my own since I was 15 years old, and I did not have a lot of guidance from my parents. And that led me to kind of make connections with other people in similar circumstances as a young adult and not really have any guidance in life. So I made some poor decisions as a younger adult. So I've been through quite a bit of traumas and unfortunate circumstances, but I have really changed my life around. I feel like with my track record, I've proven to be a very strong person and a very good person. I've done a lot for the community and for other people, and I am just asking to be given some grace for my circumstances that I had when I was younger. I have not been in trouble for almost 7 years now. I've lost my mother during that time as well, and I'm very proud to say that I'm a better person, and I've grown and rebuilt my life as a young professional, and I continue to want to do so. I'm really great with clients. I have incredible 5-star reviews all over Google and things like that. Most of my clients I've had for at least 5+ years. There's a lot of people in my corner who really support me and know who I am as a person and know my heart and my true intentions. And I'm just hoping that the Real Estate Commission also sees that in me today as well. I'm open to any questions if you need any additional information about anything, but I'm really hoping to continue my path and my career and be able to be in the real estate industry.
Commissioners, any questions for Ms. Nevitt? Ms. Nevitt, I do have one question. You said in your statement that you were in the beauty business. Is that correct?
Yes.
Is that like a
Yes.
licensed activity or is it?
Yes.
Okay, so
I actually have many other professional licenses as well. I'm a licensed esthetician in the state of Tennessee. I'm a licensed tattoo artist. I'm also very close to finishing my esthetician instructor's license as well. I do lash extensions. I do tattooing, permanent makeup. I'm a makeup artist. And I also train other beauty professionals and help them in their career as well.
thank you. Any other questions for her? Ms. Green, if you want to go ahead and speak in support of her candidacy. Unmute yourself if possible.
I'm sorry. I'm Susan Green. I've been in the real estate business for 50 years. I managed the Crye office in Gallatin. When I met Alyssa, I was quite impressed with her. She was very forthright in letting me know that there were issues in her past. I feel it's very important to give young people grace, especially when they did not have the surroundings that most children are supposed to be guaranteed with. She has attended many training events. She's in the office and also with Crye. I've been impressed with her knowledge. I've been impressed with the way she handles herself. You've already heard she speaks very well for herself. And I would find it a pleasure to be able to manage her and guide her in getting her own on her success track in the real estate business.
Thank you. Commissioners, any questions?
I have one question.
Ms.
What, can you give me, you said that Ms. Nevitt was working in your office now, is that correct?
Yes,
And what role is she
she's just
in?
coming in. She's just coming in to train. She's just coming in for sales meetings and to train. She's not, obviously, she doesn't have a license to do anything other than, she's very eager to learn and seems to be a sponge at grasping information.
Okay, thank you, ma'am.
Any other questions? Hearing none, is there a motion?
Motion to approve.
I have a motion to approve by Commissioner Torbett, seconded by Commissioner Moffett. Any further discussion? Hearing none, let's vote. All those in favor of this candidate's application, say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Congratulations, Ms. Nevitt, and good luck.
Thank you so much.
Candidate B.
Candidate B.
Is Guy Hardaway. His principal broker is Kenya Flemings. I hope I'm pronouncing your name properly. Mr. Hardaway is before us today due to a felony possession charge. He has taken and passed the affiliate broker exams. His statement and letter of recommendation can be found on the iPads.
All right, Mr. Hardaway, you got a sense of how it's going to go here? When you're ready, please explain to the commission the circumstances that bring you here today.
Yes, sir. My name is Guy Hardaway. I've passed both of my exams. I passed them on the first try. A little proud of that. But I'm basically here today because I grew up in a rougher environment. I could blame it on that as much as I want, but I was really irresponsible in my early 20s and later teen years. I grew up with a single mother. She had an incurable disease. We didn't live in the best of situations. And I hate to say the phrase product of your environment, but that's how it turned out. I've got in some trouble in my early 20s. As you can see, I've sent a copy of my records to you guys. It landed me in incarceration. I woke up in a cell and I said, I need to change my life. It didn't happen instantly. It took a little bit of time. And in that time, shortly after I made that decision to myself, I started taking any class that was provided to me. I took a class on 7 Habits of Highly Effective People, and that's what really made my life click. After that, I got my GED. While incarcerated, I took multiple college classes. I ended up running a graphic design department while incarcerated for a company called Pride. I took several college classes through them, one being visual communication and multi-design, marketing and design. I took real estate and investing classes, bookkeeping, several classes on religion, and then eventually the best way to help yourself is to help other people. So I started teaching these classes. The class on 7 Habits of Highly Effective People I taught several times. I helped teach the real estate class. Since release from my incarceration, I got into re-entered my career into sales. I was in sales whenever I was younger, and immediately after, my dad sold cars for a company here in Tennessee named Jason Lewis Automotive, and I started working with him. And about a year and a half in, I told him I was interested in management. At the time, you have to be 4 or 5 years until you're eligible for management, so they laughed at me. And then eventually, they weren't able to laugh anymore. I was the #1 salesperson for all the pre-owned stores. They own 5 stores now. And now I am the head of the finance department at their Knoxville location. Say that, all of that to say this, I want to further my career. I believe the next step in doing that and to helping other people is in real estate.
Thank you so much. Commissioners, any questions? Ms. Smith.
I have one question.
Absolutely.
You mentioned that you were teaching a real estate class. Can you tell us where and when that happened?
Yes, absolutely. So that was at a place that I met a guy named John Abbott, who was a professional real estate agent whenever I was incarcerated. We were in a faith and character-based community. So John taught a class on, he was a real estate agent and investor, more so an investor prior to his incarceration. He was extremely successful, and I can honestly say if it wasn't for him, I would not be where I am today. He was my mentor, but he taught the class, and I assisted him in teaching the class. That was at the place we were at the time was called Tomoka CI.
I'm sorry, it was called what?
Tomoka CI.
And that
It's
was,
an institution in Florida.
and where was that? In what state was that in?
Florida.
Florida. Okay.
It's just outside of Daytona.
Okay, thank you.
Any other questions? Hearing none. Ms. Plemons, you want to speak in support of his application?
Hi there. Thank you, everyone. Yes, I'm the principal broker of a company here in Knoxville, obviously, and Guy had reached out, and my staff set up an appointment with him to meet with me and them, which is standard whenever we have a recruiting appointment and someone that's interested. So whenever I didn't know anything about him, and whenever he came in, we met. He was friendly. He was, he spoke well, and but we were about 5 minutes into just, the niceties of meeting. And then he said, hey, I want to tell you where I'm coming from, what my background is. And so I really did appreciate his forthcoming with that information. He did go through everything with me. And, it's not often that, I have been in a situation like that where someone had, been incarcerated, but he did seem to me that he had changed and that he was I don't know what he was like before, but I was convinced that he is a different person. And just based on we spent about an hour together. So based on that time that he was sharing with me, I do feel like that he had gone through many courses, many certifications, many different classes and training and development courses that had caused him to really reassess his life and his vision and where he was going, where he had been, and where he wants to be. Of course, I believe in second chances. The other thing too, though, at our company, every new affiliate has to go into a mentorship program. And that mentorship program, in his case, he would have to be partnered with a mentor, and they are with him a lot. And, if he does get approved and he does join, they are with him. It's pretty stringent. It's pretty, we have a lot of training and coaching and development in that mentorship program so that agents don't make mistakes and so that agents understand how to conduct themselves. So we have a good system for him to go into. But overall, after the meeting, I did not have any concerns about if he was the same kind of person before or if he would succumb to any kind of temptations that, he had in the past. So that's kind of how I felt. And so here we are.
Thank you, Ms. Plemons. Any questions for her, commissioners? Hearing none, is there a motion?
Motion to approve.
I have a motion to approve by Commissioner Torbett, seconded by Commissioner Moffett. Any further discussion? Hearing none, let's vote. All those in favor of the application, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Congratulations, sir, and good luck.
Thank you.
Thank you.
Next,
Candidate C, please.
yes, candidate C is Ms. Fanat, and if I'm mispronouncing your name, I do apologize. She is before us today due to a theft charge. She has taken and passed the affiliate broker exams. Her statement and letter of recommendation can be found on the iPads.
All right, it's my turn to take a shot at the last name. I'm going to say Ms. Fontenot.
Correct,
If
yes.
if you're ready to speak, please.
Sure. Y'all will have to forgive me. It's kind of, it's been emotional watching the other people.
Oh, boy.
It's just, it's a long road whenever let me get it together real quick. I'm sorry.
Take your time.
Okay. I didn't really feel too emotional about this until I saw everyone else, just with relief that their past has finally been able to not hold them back. Forgive me, I'm so sorry. Okay. So for myself, I had a little bit of a different upbringing than the other two people, but I actually grew up in a really normal family. I had a great upbringing. I knew right from wrong. And everyone was actually very shocked whenever I got into using drugs. Um, so the people that I chose to hang out with whenever I was in high school were all on drugs. It led me to, start trying them. And then one thing led to another, and I found myself addicted to opiates. Unfortunately, that is very common nowadays. It's a really sad epidemic. But so obviously, under the influence of drugs, I made very poor choices. It just caused me to be a different person than I am. And under the influence, you were willing to do whatever it took to continue on with your addiction. I got sober in 2018, and at that time, I was trying to find a job. I was waitressing. It was very difficult because I had the legal charges behind me. So at that time, I decided to start a cleaning company. I didn't really think it was going to go anywhere. I wasn't really looking to, be a business owner. I just needed some extra income. But I mean, I went full force at it, and it's actually been very successful. I still have it today. I've had numerous employees. The same with the other lady. We have excellent reviews on Google. It's a licensed and insured company through Tennessee. I've been able to, like I said, have other employees and manage them while still working in the company myself. So I have numerous clients that trust me in their home and that trust me to say that this person is a trustworthy person to come into their home. I'm raising my children. I'm married. My life has just completely changed. And honestly, this isn't really something I like to talk about very often because I just wanted that version of myself to kind of be forgotten. So it's honestly a little uncomfortable for me right now, but I do understand the reasoning behind it. But yeah, I don't know. I don't really know what else to say. My hopes are that I can merge these two together, that real estate and a commercial and residential cleaning company will go nicely together and they can play off one another. I know multiple people in this industry, and several of them have told me over the years that we think you would be great at this. I've always been a hardworking person, and I just think that I could really do well in this industry. And I really like to work with the community as well. That's why I kind of was bartending and serving before. I love to work with the public, and that is one aspect that I miss a little bit with cleaning. You're kind of working by yourself every day. So I look forward to that if given the opportunity. And I think that y'all have the letters of recommendations from some of my clients and others. And yeah, I guess that's it. If y'all have any further questions, I don't feel like I was very thorough there, but please let me know.
Thank you so much. Any questions for Ms. Fontenot?
I have one.
Ms. Smith?
Yes, I think in one of your letters, it says that you're still participating with Cedar Recovery addiction treatment. Is that correct?
Yes, ma'am, it is.
Is that a monthly meeting? Is that something you feel that you should be involved in for a long time? How does that system work?
Sure. So since I've been going there since I believe 2018, I go, I do a therapy group once a month, and then I go in like once every 3 months, and they do a drug screening. It's not required or anything. It's just something I've continued to do, and I guess I think it's held me accountable in those early couple of years. But I don't know how I feel about it, just to be honest with you. I think that if I discontinued it, I would be fine either way. But I have found it helpful to do the monthly check-ins with others that have been in the same situation.
Commissioners, any other questions? I do have one question, but it's for counsel, Ms. Matlock. So normally these are a 10-year look back, correct? So her last charge was in 2015, so but her probation ended in 2018. Is that why she's required to appear before us today? Okay, thank you. Mr. Sargent, if you would like to speak in support of her application.
Yes, and first let me thank the members of the commission for allowing me to be here today to speak on her behalf. She was referred to me by one of our agents, and I oversee, I'm the broker at one office, but as the general manager and CEO of our company, I oversee 5 of our Keller Williams locations. She was referred to us by one of our current agents, and very upstanding guy, former career in law enforcement, highly respected within our office. But Ms. Fontenot was referred to me by him, and in talking with him, he gives her a ringing endorsement. And digging in a little bit more to the story, I learned that he was actually at one point an arresting officer with her, and he, it just I wholeheartedly believe that she has worked hard to change her life. We're a company of opportunity. I think we're an industry of opportunity. And I hope that you can see the sincerity in her, because I believe it. And other members of my leadership team who have met with her would say the same. We believe she's changed her life for the good. And I would be honored to serve as her broker if you guys would be willing to pass her through.
Thank you, sir. Commissioners, any questions for Mr. Sargent? Mr. Sargent, I'd like to, are you going to be her supervising broker, or is somebody else going to be?
I will be. I
Okay.
will be. My broker's license hangs at the office that she will be joining, so I will be her managing broker, as well as, the leader of our whole company.
Thank you. Commissioners, any other questions for Mr. Sargent or Ms. Fontenot? Hearing none, is there a motion?
Second.
I have a motion to approve by Commissioner Gwynn, seconded by Commissioner Tucker. Any further discussion?
I would just like to add that I would like to commend her for her recovery and her openness, because not everybody that comes before us is as forthcoming. And I just would like to congratulate her on where she is.
Thank you.
Thank you, Ms. Torbett. If we're ready to vote, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Congratulations, Ms. Fontenot, and good luck.
Thank you. I appreciate it.
Candidate D, please, Ms. Baker.
Candidate
Thank you all.
Candidate D is Malika Roberts. Ms. Roberts is before us today due to a suspension of a nursing license. She has not taken the affiliate broker exams. Her statement and letter of recommendations can be found on the iPads.
Good morning, Ms. Roberts. Please tell us the circumstances that bring you before us today.
You're still on mute. If you could unmute, I can't do it from this end. You'll have to press the unmute button. If you look at the top, it's 2 over from the leave button.
Okay, can you hear us now?
You can.
Okay, thank you.
Okay. Good morning, everyone. I'm here today because of disciplinary action that happened due to an incident back in March of 2022. I made the mistake of taking medication that was offered to me by a coworker, which led to a failed drug screen. The disciplinary action required that I enroll into a TMPAP monitoring agreement, which I did. And during the monitoring agreement, I was working at a facility and I was being bullied quite often over the situation. And it really, honestly, affected me a lot. I was having a hard time trying to navigate through that. And cope with everything that had transpired. You know, at that point, I felt like I'd ruined my life, you know, and it started to affect all areas of my life, my home life, my relationship with my children, my husband. And I felt like at that point, my best choice was to temporarily step away from the nursing profession and the monitoring program, to put myself first to fully heal from what had happened, and to try to cope in a healthy way. But unfortunately, when I stepped away from both, my license was automatically suspended. But I have put a lot of work into myself since that point, and really focused on healing. I've completed an intensive outpatient program with individual therapy. I attend 12-step meetings at least 3 times every week. I have an amazing sponsor that I speak to every day. And I now have like the most incredible support system I've ever had in my entire life. I have been taking the steps to get my license reinstated. But honestly, you know, after countless hours of thoughts about it and a million prayers about what to do in this situation, I no longer feel like that is the path for me anymore. I've dreamed about real estate for several years, and I'm finally ready to pursue my dreams. Ultimately, you know, it's been almost 3.5 years ago now. I made a mistake and I take full responsibility for it. I've learned very valuable lessons throughout this, and I really focused on trying to take this negative situation and turn it into something positive in my life. And it really has. It has changed my life for the better. The only thing I'm really missing at this point in my life is my career. I have completed the real estate courses. I have passed the licensing exam. And I'm here today respectfully to ask for the opportunity to start a new chapter in my life. Thank you all so much for your time and consideration.
Commissioners, any questions for Ms. Roberts? All right, I'm going to go ahead and all right, I'm going to go ahead and ask Ms. Roberts. I'm just trying to understand the incident as the origin of this. So you were handed a medication by one of your fellow nurses. You took it. You failed the drug test. So all of the
Yes.
treatment programs and all that, was that because there was a problem with addiction already, or did the event itself cause the addiction? I'm just trying to understand the aftermath that you're going through.
No, the TMPAP monitoring agreement was required to continue working. But then when I pulled out and temporarily ended that, and I went to restart, I'm currently back in good standing with them. But then restarting, they required for me to complete the IOP, which I'm thankful they did, because it truly changed my life. Going through that and going through the therapy.
So there's not an underlying addiction that is being treated. This is just part of the program to kind of get back to where in good standing?
Yes, sir, it is.
Okay.
Ryder, the therapist that I went through the IOP program with, submitted the letter of recommendation, and he listed on there that there's no issues with addiction.
Okay. So you've completed your programs. Are you going to continue to seek counseling for addiction or other reasons?
I am still in good standing with my therapist, just to keep a relationship there, just for daily life. You know, I think it's
Okay.
very beneficial.
Okay. Commissioners, any other questions for Ms. Roberts? Mr. Byrd, sir, your turn.
Yes, I'm Lynn Byrd. I'm principal broker of Byrd Home Team Realty in Kingsport, Tennessee. Been licensed since 1993, been principal broker since 2000. I met Michaela several weeks ago, and I smiled there once when she mentioned her program. My wife is actually her AA sponsor, and that's how I originally met her. I knew her father from working at Eastman Chemical Company. Just knew who he was. I didn't know the family personally, but in the last several weeks, I've gotten to know Michaela very well. She sat down and told me her story and her situation, and in depth. I also had her write it up to send in just what she told me to the Real Estate Commission. I found her to be very diligent. I have seen no indication of any problems with any drugs or anything. I'm actually a member of Al-Anon myself, which is, I don't know if everybody's familiar with that, but it's a program for family members of alcoholics or addicts. I've been a member for almost 15 years. I have children myself that have had alcohol and drug issues over the years. My wife does sponsor, Michaela does attend the meetings on a regular basis. And again, the 12-step program, the step one is I'm powerless over alcohol, or it can be I'm powerless over blank. And I look at it as a life program. In Al-Anon, we use the same 12 steps that are used in AA and NA and all of the programs, 12-step programs. But in my opinion, I have seen no indication that Michaela has any kind of drug issues whatsoever. I think she made a mistake, made a bad decision, took something from a coworker, and it was just a bad decision. She has been attending our office training sessions. We do a training session every Friday morning at 10 o'clock. She's attended 6, 7 sessions now, and she's always on time, very diligent, willing to learn. And I will be supervising her real estate career with our company. My wife, again, will be mentoring her somewhat as well, and we would be happy to have her as a member of our real estate organization.
Thank you, sir. Commissioners, any questions for Mr. Byrd? Hearing none, is there a motion?
So moved.
Is that a motion to approve?
Excuse me, motion
Thank
to
you.
approve.
Got a motion to approve by Commissioner Smith, seconded by Commissioner Moffitt. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Congratulations and good luck.
Thank you
Thank
so
you
much.
very much.
Ms. Baker, candidate E, please.
Candidate E is Tamitha Cox with Principal Broker Real Cup. Ms. Cox is before us today due to larceny charges. She has taken and passed the affiliate broker exams. Her statement and letter of recommendation can be found on the iPads.
Good morning, Ms. Cox. Please tell the commission the circumstances that brought you before us today.
Good morning. I'm actually just going to read what I put for the explanation of the conviction. For about 20 years, I was maintaining my sobriety while working my way up in position from a client to the director of a women's recovery program that changed my life in 2001. During this time of about 20 years, I was able to help out hundreds of women through residential treatment, outreach on the street, hospitals, as well as prisons and jails across New England. I pursued many vocational trades such as personal training, nutritionist, as well as becoming pretty successful in my real estate career in Massachusetts as well as Rhode Island. I did a lot of things. I considered myself successful because of my achievements and the accolades from those around me. Yet I was struggling to maintain an image of a perfect marriage on the outside, yet was completely dysfunctional in my home. I struggled for many years with my husband's infidelity, gaming addiction, and constant full time narcissism. I realized I worked so hard and did so much for the community because it was uncomfortable for me to face the lack of intimacy on all levels in my own home. In 2021, something broke in me, and I could no longer maintain this image that I was trying to uphold for the years. I begged my husband for counseling and to end his online relationships. What hurt me the most was his unwillingness to change these things, to pursue a healthy marriage with me, and just to be honest about it. I decided to relapse after 20 years and pursue drugs to numb and cope with my feelings, knowing how destructive and dangerous this would become. At this point, even though I had achieved many things in my life, I still felt unloved, unworthy, and most importantly, isolated and alone. Because of my choice to pursue addiction, I lost my career, my relationships, my house, my dogs, and all hope that I would actually even have a better life. I was willing to die, and I quickly ran through all the money from selling my house, staying in hotels, living in my car, and eventually homeless on the street. In this time of 2021 to 2022, I chose to steal from stores, people, to support my addiction when I became homeless. I was a battle to survive on the street. I ended up on Mass Avenue in Boston, living in a U-Haul truck. I overdosed almost 100 times, but it's mercy and grace that allowed me to live and have a sound mind each time with the help of Narcan also. In 2022 of December, I had a praying community in Greenville, Tennessee that encouraged me to leave Boston and come to Tennessee to receive help through a residential program called Recovering Hearts, and that I needed to face concerning my prior life as well as the passing of my first husband in 2021 and my fiance in 2023. I honestly didn't want to face my relapse consequences considering my legal problems, as you are all well aware of. Yet I saw a responsibility to God and to myself for allowing me another chance at life. I'm a completely different person today. I've been actively pursuing my recovery and have a great community around me that support me. I'm in counseling and still work on many levels on many of my issues that led me to my relapse in the first place. I believe I have the skill set because of my prior real estate career in Massachusetts and Rhode Island. I did well, and after praying about it and giving it consideration, I believe I was to start my career here in Tennessee. I did not know that I would have to go through the process and face all of these legal situations and the consequences of everything, but I do trust the process that has been in place to allow me to explain my situation and ask for an opportunity to prove my integrity in the state of Tennessee in pursuing my real estate career. These charges were a very short time in my lifetime of success and being an asset to the community. I have made restitution and have even served jail time because of these incidents. I appreciate your consideration and allowing me the chance to go before the board and hearing my story. And all I know is that nothing is impossible with God. He has done a million miracles in my life. I am currently a productive member of society while actively cleaning Airbnbs and driving for Grubhub. God, in his great love for me, has allowed me to be married to my now husband of almost 2 years and has completely changed my life. And it's an honor to be part of his plan. We are looking to give back however we can, share our stories however we can, because that's the one thing that I have found in these past couple years is hope and gratitude that I don't have to just live to maintain an image for others, but I can actually live in an authentic way, to be broken, to lean into support from those around me. And it's the best feeling. I believe my brokerage and the real estate community will also be an excellent source of strength for me too in my journey. I appreciate you for taking the time to read this. Thank you so much.
Thank you, Ms. Cox. Mr. Cupp, if you want to speak in support of her application.
Um, we're a faith-based company, and Tabitha came and interviewed with me, and everything that she says, I've seen. She was referred to me by one of our vendors, and he leads that faith-based organization she talks about. He said she was a leader there, that she was she put herself out there. I think for everybody that you talk to today, it's going to be a journey. And Tabitha's put in a lot of time. She's led a ministry at the local youth prison here. And she's also a leader in that church, according to Vince. She has an amazing determination. And I believe that she chose the toughest path we have in here, which is we have a group that holds you accountable every week. You have to show up and you have to tell us what you did. They stay with you through the deal. I'm a very hands-on broker, and I hope to be able to help her move forward.
Thank you, Mr. Cupp. Commissioners, any questions for Ms. Cox? Ms. Cox, I did want to ask, you said you had a career in real estate in Massachusetts and Rhode Island. Did you hold a license
Yes,
in both
sir.
those states?
I did, yes, sir. So I was actively selling real estate during all this time it was happening. I had a great brokerage. I honestly remember receiving my letter just to update my classes and such to get my hours in for the 2 year that I was getting ready to lapse. And honestly, I just let them expire. I just stopped caring. So I came down here and I just studied and I did the whole thing all over again.
Okay.
And I passed it. So yeah, so I plan to be diligent if I'm going to prove to keeping my everything up to date, with my education. And so
So there were no sanctions or any disciplinary action in
no,
those states?
no, no. Yeah, I did pretty well. I sold some real estate in Boston. I specialize in first time home buyer seminars. I worked with many lenders and just did a lot of networking. I had a lot of fun with it. It's just, as I said in my testimony, it was difficult for me to have so many hats that eventually a few had to fall off. So
Okay. So
now
the point is,
yeah, yeah.
so the point is you're not a brand new real estate agent. You're just getting back into the business?
No. Yes, sir. I
Okay.
prayed about it and was just looking for I'm not trying to work harder. I'm trying to work smarter here. So I felt confident about everything I've read about the real estate commission and the meeting Will and the brokerage. It just really boosted my confidence that I feel like I could do well.
Okay. Thank you. Commissioners, any other questions for Ms. Cox or Mr. Cupp? Hearing none, is there a motion?
Motion to approve.
I have a
Second.
motion to approve by Commissioner Torbett, seconded by Commissioner Moffett. He beat you, Kathy. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Congratulations, Ms. Cox, and good luck.
Thank you. Thank you.
Amen. Thank you. Thank you.
Thank you.
Ms. Baker, next up, I think, is the informal request, or I'm sorry, the waiver request.
Yes, we have 2 waiver requests today. The first waiver request is Raymond Arson.
Ms. Baker, if we could,
Yes.
I wonder if we could switch the order, if we could take on Ms. Tipton McGee first and then Mr. Arsenault. Can we do that?
Sure.
Commissioners, any objection? Thank you. Ms. Tipton McGee, please.
One moment, let me pull that one up. It is 04B on your iPads. 04B on the iPads.
Thank you.
Ms. McGee is requesting a medical waiver for civil penalties and reinstatement fees. Her retired license expired March 22nd, 2024. Her statement and records can be found on the iPads.
Commissioners, any questions about this waiver request from Ms. Baker or for council? So this is the applicant. She was taking care of her father?
According to her statement, yes.
Right. Was there any sanctions or disciplinary actions on her license before?
No.
Oh, okay, I see it now.
I've got a quick question.
Her license was in retired status when it expired.
So her license was retired, and the 1,100 is for a year out, or is that,
It's, I believe, $50 per 30-day period for the first 90 days, and then I think it goes to $100 per 30-day period until day 365.
so her license expired,
While in
her
retired.
retired license expired
Correct.
in '24,
Yes.
so the 1,100 would catch her up until now?
Correct. That's the maximum.
Oh, it is? Okay.
And she's asking us to waive the fee?
Yes. And to bring her license current, typically she would pay that fee. If it was prior to March 22nd, she would pay that fee and take 16 hours of continuing education. But as you all know, the law changed last year that if you expired in a retired status, you take additional 16 hours of CE per term that your license was expired to get your license caught back up.
All right, so if she expires, so she would only get needed 16 hours?
I would have to double check to see how many hours she took between 22 and 24. So she would need to take anywhere between 16 and 32 hours.
Okay. And does that require the core course and all that
yes.
stuff plus electives?
Correct.
Okay. So so there's the education, there's the fine. She wants us to waive both, one or the other.
There's a civil penalty.
Okay.
1,100.
Yeah, the fee.
Yes.
That's the fee.
Yes.
That's the fee you were
Yeah.
talking
That's the
about.
fees, plus the other fees with bringing back her
Well,
license.
reinstatement fee is $75, and that's what everyone pays in order to renew their license.
So she's looking at 1,100 plus 75 plus education.
Correct.
Okay, thank you.
And does that get her back in retired status or in full status? Or what is she asking for?
If she's in retired status, it would put her back in retired status and then an additional $25 to move it from retired to active,
All right, so another 25 to that. So it's 1,200 in effect.
as well as proof of E&O. We would need that in order to activate her status as well, or have her in an active status, rather.
Commissioners, what do you think? 'Cause-
Will you turn on your mic, please, Commissioner Torbett?
I would be okay with waiving the fee and just do all the required education and reinstatement fee.
Are you saying
I
waive
have-
1,100? But the 75 and the 25 would have to be paid?
Yes.
And the education?
Yes. Maybe I should make a motion. I'll make a motion that we accept this request for, hold on, pull it back up. For the $1,100 civil penalty or fee or whatever it is to be waived, but still complete everything else required to reinstate the license. So the reinstatement fee, the 16 hours, right? Ms. Baker, 16 hours?
Or 32.
Or 32?
Or whatever it
Okay.
is, yes.
So if I can restate. So the motion is to just waive the $1,100 civil penalty and allow her to pursue reactivating her license by completing education and paying the associated fees.
Correct.
Is there a second? So that motion was made by Commissioner Torbett, seconded by Commissioner Moffett. Any further discussion? Mr. Gwynn?
I've got a question. So she's asking for a medical waiver,
Yes,
not on herself, though,
for a family member.
for a family member. Is that,
In FMLA, it's for yourself or a family member typically. But you guys have the option of granting the waiver
Okay.
because of the way the statute's written.
But it is her license, right?
It is her license,
Okay, but
yes.
she was just taking care of a close family member.
Her father, I do
Her father.
believe, yes.
Yeah, okay. Any further questions or discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
All those opposed? Hearing none, that motion carries unanimously. Mr. Arsenault, Ms. Baker.
Thank you. Mr. Arsenault is requesting a fee relief, a one-year extension to complete 120 hours post-CE from today's date, and an automatic upgrade to a broker's license once his CE is completed. He obtained his broker's license November of 2014. It expired November of 2018. His statement can be found on your iPads.
Okay.
I don't understand this exactly.
I'm sorry. say that again.
I just would like a little bit more clarification of what happened here, where he says it was a conflict of interest with his new role, so he didn't keep his license active. Like, can you give us some more insight about what's the role there?
He is present today. If you would like him to answer this question, would you all be opposed to having him answer this question?
Ms. Arsenault, please, sir.
All right, good morning to the commission. Thank you for the opportunity to be able to speak.
Turn that mic towards you.
I'll turn it towards me. Let
You
there.
can move the.
Okay, like
there,
that.
yeah.
Okay, all right. Sorry, I've never done this before, so and I'm nervous. So I got into real estate business. I got my real estate license in 1998, straight out of high school. First thing I did was the best thing ever to me. Right, it changed my life, and end up, years later getting into staying in real estate. I graduated from MTSU with a real estate background in my undergrad, got my MBA, and in undergrad, 2009, the world fell apart, so I never got another job in real estate. And so in 2017, 2016, I saw something about a job at the state of Tennessee in the real estate stream. State asset management. They're on the 24th floor there of the tower, and I got a job there. And during that time, I was told that it was a conflict of interest. I was a land agent. That was my title, land agent. And so, my grandfather told me, well, son, that's one of the best things you can have, a state job, real estate, you're finding your way. So at that time, it was told that I couldn't, actively do real estate. It'd be working for the state of Tennessee, being a land agent. And so during that time, I had already got my broker and stuff, and I was going to be working on that to do that 120 hours. This was my job. This was what I was doing at the time, and I figured I would be at the state forever, honestly. And then 2020 happened, and then the world changed. And so I'm here asking for grace from the commission. I'm a single father. I have two sons. I have an 11-year-old, a 14-year-old, and one just started high school. And so I'm asking for grace today to be able to at least have my affiliate broker license back and let that 3-year reset for the 120 hours, and I'll go and get the broker license back once I complete that. But I'm just asking for the grace from the service I provided to the state of Tennessee for 4 years. There, I was a good employee there. I did things I did for the state, and just asking for some grace. I didn't find out about the rules that you all have until I watched the commission meeting, that I could have actually asked for that and put my license in retirement back then and still had it active. And so I'm just asking for the affiliate license to be reinstated and just give me some grace here. That's all I'm asking the commission this morning, based on your discretion of the law. Thank you.
Thank you, sir. Thank you, sir. So in the summary that you provided us, we have a license expiration date in November of 18.
Correct.
He just said that he didn't retire it. So he, at this point, the status is right now, he has the civil penalty that is still there.
He would be a retest reapply candidate because it's been longer than a year.
Okay, so retest, reapply. So that civil penalty goes away?
If you retest and reapply, however, if it's reinstated, the civil penalty attaches.
Okay.
So retest and reapply would give him a completely different number?
Correct. No, it will not give him
Same
a
number.
It's the same number, yes.
What options do
So,
we have
so it's
here?
been 7 years, essentially.
Yes.
Okay.
I'm just curious, what have you been doing during this 7 years?
That's a good question. So I've been in real estate. So after I left the state, I ended up getting into tech, but I ended up getting a job at Amazon's Real Estate Worldwide, a project manager there. I was there at Amazon, and currently now I work for one of the biggest healthcare companies in Nashville in the project manager role as a real estate project property manager. So I've still been in real estate and everything, project management. And yeah, so real estate is really, something, the one thing is that over the years, I've had, old brokers call me about opportunities because I actually specialized in commercial real estate. And I tell you, I had a call probably about 2 years ago from a old broker, and they basically do residential. And he said, well, we got a call, and they want to have an apartment building for sale. And he said, and it's probably about $2-3 million listing. And the first person I thought of was you. And, my stomach curled up. I was like, well, I don't have my real estate license anymore. And so so that's what I've been doing. I've still been in real estate, but in the corporate side, working for Amazon, working for my current company, I won't say, but yeah, so I've still been in real estate, but I would really love to be able to get that license back to get some more income, especially beating AI, because I feel like my job at my current company is going to be gone in a few years with AI competing against me. So I got to get out there and make some more money, build some relationships, and use those skills that I've had.
What, can you tell me what project manager means?
Yeah, so what I do currently, at Amazon, we have all these warehouses all over the world now. Basically, I would interact with the landlords when we needed to do alterations to the facility. So if we need to take off a side wall to put in more drive-in doors to the Amazon Prime drivers, coordinate that with landlords and the project teams on site to make sure who's responsible for this, and if we have to return the property back to a certain state after we're done with that lease there. And currently, what I do, I forecast for the healthcare company. We find locations throughout the United States for employers or unions where they want to have a near site or an off site for their employees or their dependents to have a healthcare clinic. And so what I do there is from when our VP gets the lease, I go through the lease, make sure that all the deliverables that we need to provide for our tenant reimbursement or any type of TIA dollars that we need to get back, utilities, everything from day one, from when we initiate the lease to turn it over to our ops team. I'm all in those, managing those relationships with finance, legal, and our operations teams, and just make sure that we stay on board on when it's time to turn over that clinic, because if the client's paying us to deliver a date, we got to meet that date, so.
Thank you.
You're with Amazon now, is that what you said?
No, I'm currently with Premise Healthcare.
Okay.
Premise Health. Yeah.
They don't have a broker's license, do they?
Oh, no. They outsource that. They
Does
have a
Amazon, out of curiosity, or do you know?
Amazon, they were with CBRE. I would say something, from what I remember, most of the tools we use were CBRE.
So,
Go.
so my question is for Anna or Denise. So he's requesting fee relief and an extension to complete his CE. If that didn't happen and he retested and reapplied, what's the difference there?
Testing. So he could, you all could grant today to grant him an affiliate broker's license without retesting and reapplying. Or you could allow him to have this extension, or he could retest and reapply and become a broker again. And then that would restart the 3-year period of which he would have to complete the 120 hours.
So if he retests and reapplies,
As a broker or an affiliate broker.
as an affiliate broker, I
Okay.
guess. I'm just wondering which would be the easiest option there. So if he retests and reapplies as an affiliate broker, does he still pay the fees?
No. However, you all could grant today to allow him to have an affiliate broker's license and maybe take the trace course, or you could grant him an affiliate broker's license and waive the fee the reinstatement fee, or you could grant him a broker's license and waive the fee. You guys have lots of options. Hopefully Trace would be in one of those options you all decide today.
I guess I'm a little uncomfortable. Here we go. Nope.
Here, I'll turn mine on.
I guess, and pardon us, but we're having a discussion in your presence. I guess I'm a little uncomfortable about granting a broker's license when someone, although he's been in a real estate world, he has not been a practitioner since 2018. So that option, I don't think is in my wheelhouse, to grant him a broker's license. Now, my next question is, if you've got to do 120 hours regardless, then you could retest. So the main thing, it looks like to me, is whether or not the fee of $1,100.
If you were to grant him a broker's license today, theoretically, since he's already had his CE, he could apply to be a broker tomorrow and retake the exam.
Okay.
So if you were to allow him to be a broker today, he would have 3 years to complete the 120 hours.
Okay.
If he took the Trace course, hopefully.
Okay. And that Trace course is now available, correct?
Hopefully in about 15 minutes, 20
Okay.
minutes.
That's pretty quick. Thank you.
So if we grant an affiliate broker, then from what I understood early, he's willing to take the classes to get back to broker status over the next few
Well, he's
years.
already taken the classes. And has had his license for more than 3 or 4 years. So he would automatically be eligible for a broker's license. So if you were to grant him an affiliate broker's license today, and once the paperwork was done on our end, he could come back the following day and apply to be a broker and sit for the exam.
Right.
But he would have to resit.
Yes, he would have to resit for the exam if you were to grant an affiliate broker's license today.
So, but as he stands right now, he's a retest and reapply.
Correct.
So I guess the question is, if we let him retest and reapply, the civil penalty, the $1,100 civil penalty goes away, and then a 3-year clock starts before he can be a broker again. Or,
The next day.
Well, he stated, will you repeat that to make
I'm
sure?
saying if he retests and reapplies as an affiliate, right, does that resets the 3-year clock, does it not?
Correct.
I don't think so. He already has the education requirements in the past,
He hasn't completed the 120.
but he did that in the past. I don't think he would have to retake it.
Well, repeat your question again. I may.
Yeah, I'm just
not
trying to
connecting
see-
the dots.
There's if he retests and reapplies and he's issued an affiliate license
If he retests and reapplies
to be
for an affiliate or a
an
broker?
affiliate broker,
Okay,
does that reset the clock for a broker's license?
no.
Okay. So
I
it
don't
seems,
think I understood that question.
We'll have counsel weigh in.
So I think regardless of what's happening here, he would be able to apply for a broker's license because he already has the amount of years required to be a broker at this point. So it's just whether you want to go ahead and have him reinstate his license as a broker, which would mean he would not have to take the test. Or if you want to reinstate him as an affiliate broker, which means he would have to take the test, but he could immediately apply to be a broker because he already has the education, the requirements to be a broker.
okay, so if we bring him back as an affiliate broker,
Yes, he would have to
And-
take the
and so-
broker
so
examination
yeah.
again.
but does he have to get the education again?
The 120
Post-CE?
Post-CE, yes. He would have to get the 120 post-CE either way.
But not the pre-license?
No, not the pre-license. He's already done it. So like the reason he's here is because he doesn't have the 120 post-CE.
So back to his request, he was wanting a 1-year extension.
Yes,
So basically, during that 1 year, he's going to get the 120, but no fees, right? Or how does that work? Meaning,
That is his request.
so
However,
really what we're saying is we're waiving the 1,100. We're giving him 1 year to get 120 hours, at which point he's once he does the 120, then he's squared away,
Right.
correct?
And if he did not complete it within the 1 year, he would be downgraded back to an affiliate broker.
But no fees accrue during that 1 year, right?
Correct. As long as, because the fees are there because his license was expired.
Commissioner Torbett.
I make a motion to approve his request to be reinstated as an affiliate broker, waive the fees, and have an extension of 1 year to complete the 120 hours.
And that would be,
So, let me ask one question. So, us doing affiliate broker or brokers, just like adding a step that he has to come back in a day or two to switch it, right?
Affiliate broker, it would, if affiliate broker versus broker, the difference is the test. He's gonna have to take the 120 hours CE unless you were to waive it for some reason anyway, but the difference between reinstating as an affiliate is to take the broker test. If you reinstate as a broker, there is no test, but he still has to complete 120 hours for the post-CE.
I have a question. Do you have a company that you intend to go to work with as an affiliate broker? Okay, so there's a,
If we could get that on the record, if you would speak into the mic, please. Thank you.
Yes, I do have a company that I will go affiliate with.
and there is a principal managing broker at
Yes.
that company, is that correct?
Yeah, there is a principal managing broker at that company that I would be under, yes.
Okay, thank you.
So I'm going to restate the motion. Commissioner Torbett made the motion that we reinstate him as an affiliate, waive the civil penalty of $1,100, and give him the extension, 1 year extension to complete his 120 hours post-CE. Is that correct?
And that was as affiliate broker?
Affiliate broker, because it's my understanding that
Yeah,
you
you-
would have to retest
Mhm.
if we reinstated as principal.
Ms. Torbett, if you could use the mic.
So it's my understanding that he would have to retest if we reinstate as an affiliate broker. If we reinstate as a principal broker, he would not have to retest and would immediately be principal broker, but still have to do the
He would
120.
immediately be broker, not necessarily principal broker.
But
He could
broker.
become
Oh, got
principal
it.
broker
Got
if
it.
he is a broker.
Yeah, that's,
And
Do we
my
have,
sorry.
do we, go ahead, Ms. Matlock, go ahead.
If he were to be reinstated as an affiliate, he would have to take the test, but I believe, unless someone corrects me, that the 3-year time would reset.
It would.
For him being a broker to upgrade.
So he would be an affiliate broker. Next week, he decides he wants to become a broker. He takes and passes the exam. The 3-year clock for the 120 hours begins the moment he passes, the moment he submits his broker application to us once he passes the exams.
Okay.
So, to put that together, he has to wait 3 years to be a broker.
Negative.
No. So he doesn't have to wait any time. Either, the only time that he would have to wait to be a broker is if you reinstated him as an affiliate and take the test, and he has to pass the test. So that's on him. He doesn't have to wait any amount of time to take that test. He can sit for that test if you were to reinstate him tomorrow.
Okay, I have another question. Do we have the ability to request that he not become a managing broker for a period of time? We don't have that control, do we?
I don't believe so, but I'll defer to counsel.
No, I don't believe so, because it's really the principal broker difference is just, the principal broker difference, it's not really in statute, it's the difference of checking a box on a form.
Okay, thank you.
But you do get the different responsibilities, but that's not specifically in statute. So the reason that he can become a broker the next day is because he already has the amount of the amount of experience done with his license beforehand. So that's why he doesn't have to wait any time to become a broker.
Do we have the discretion to require additional education besides the 120?
For what?
like the broker core course.
I mean, if you want that to be part of the 120,
Or you could, I know there's an open motion, but you could instate him as a broker and prior to doing that, taking the trace course and still waive the fee. That's an option as well.
My question, well, my statement would be if he can pass the test, he can pass the test.
Yeah, listening to him talk, I think he's gonna pass the test.
Me too.
He knows more about real estate than most people we see here. I mean, to start this, when I read about this, I was probably not for it, but after just having him speak for a little bit, and he's been in the industry, I'm a lot more comfortable with either way, really.
I'll second Joe.
Well, we have an open motion, so
Well, I'm reiterating what Joe said.
just making sure for the
I have no
record.
problem with the guy getting his broker's license.
Okay.
I mean, he can get a job in a flash.
so the difference, so just to be clear, just one more time for everybody, is whether you want him to take the broker test or not, really, or pay the fees. That's what we're looking at today, because he's still going to have to take the 120 hours post-CE because he has not completed them. Regardless, either way, the 100, unless you were to waive it. But I don't think that's going to happen. So 120 hours CE is going to happen either way.
So is the motion on the table for a broker or affiliate broker license? Affiliate broker, okay.
He could retest tomorrow.
So that motion was made by Commissioner Torpid, seconded by Commissioner Moffett. So any,
Did I hear trace as a part of affiliate broker or no trace? Okay.
Can I amend the motion, please?
friendly amendment?
Friendly amendment to add trace education also.
On top of the 120?
And that can count in the 120, correct or not? Okay.
We can make it so it could count towards the 120.
And that was how many hours?
30.
30,
Yes.
okay.
Or you could give him a broker's license and prior to getting that license, have him take the trace course, get the broker's license, and then that starts the 3-year clock for the 120 hours. That's an option as well.
All right.
We almost need a chart for a.
So just to understand what the current motion is going to do, we're going to reinstate Mr. Arsenault as an affiliate broker. We're going to waive the civil penalty of $1,100. And then we're going to have him reapply to be a broker, complete the 120 hours post-CE, part of that to include the trace course.
Do we need a second?
Yes, and that you'll have 3 hours to do the 120. 3 years to do the 120.
And that, Mr.
Not
Moffett, is
3
that
hours.
acceptable to you, sir? So so does everybody, you want me to say it again?
I got that one, but what if I wanted to change the motion? Do I just vote on this
We've
one
had
and then redo a
amendment.
motion, or do I do friendly amendment?
Friendly amendment, because if we vote.
Do we have?
Okay. Okay.
I don't believe we have a second on Ms. Torbitt's amendment. We
It
did.
was Mr. Moffett.
Okay.
On the friendly, we did not.
Would it be
Oh,
easier if I
he
withdrew
accepted
my
your-
motion
he
for a
accepted.
new motion?
I think.
All right, I'm going to withdraw my motion in lieu of Joe making a new motion that sounds like it's similar. Avoid having to vote. Not pass.
I want no complaints about how long this meeting's running.
I've withdrawn my motion. Go.
I'm going to make a motion to give him his broker's license after he completes a 30-hour trace course, and we'll waive the fees.
And you're granting him the 1-year extension to do the 120.
But he doesn't need it if does the 3-year clock start?
No. If you give him his broker's license today, he needs an extra year.
Would that be 4 years?
The one.
Okay. So
So
We will
my
grant him-
understanding is he gets his broker's license on the contingency that he completes the trace course first. Then he can get his broker's license, and then he would need to complete the additional 90 hours within 1 year.
Correct.
Okay.
Do I need to restate that or no?
You can just say what Anna said, which is what it should always be, but yes.
I mean, yeah. You got that, Ms. Baker?
I believe so. I'll just
the-
watch the video.
All right. At the risk of inviting more comments, any other further discussion on the motion?
Moffitt seconded.
Moffett seconded.
Yes.
All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Good luck, Mr. Arsenault.
Next, we have an Open Meeting Act presentation. I don't know if you want to take a brief recess prior to that. We also have the education report and executive director's report to do prior to the legal report.
Commissioners, you okay to push through, or do you want to break?
How long is the open meeting? I say,
20 to 30 minutes.
okay. Let's push forward and then do education. And then do a break.
Well, do you want to just,
He won't get to see if he leaves.
normally we stop at the public comment period,
You're right.
but if we're going to do the Open Meetings Act,
I'm good. I'm good.
commissioners, everybody good with that?
All right, we shall proceed with the Open Meetings Act and Public Records presentation given by Program Counsel Anna Matlock.
Did you want to sing it? No. But at least you don't have to like turn around. At least you don't have to like turn around like if we were in 1A. So, okay. Good morning. As all of you, I believe at this point, have sat through this presentation at least once, I can promise you'll hear at least one piece of new information. So, we do the open meetings, public records request update every 1 or 2 years, just so everybody can be aware of the information because it is very, very important. So here's our disclaimer. It's going to come up here in a second. I'm not going to read it, but essentially we are letting you know that the information that's being provided here today is not like specific legal advice. So if you have any legal questions related to it, let us know. And then a whole bunch of other things too. But that's the general disclaimer of what we're trying to do. Also, the information is not 100% encompassing, so there may be additional information that's not included in this Public Records Act, Open Meetings Act presentation. So if you do have those questions, please let us know. Let us, meaning me. Okay, so the first thing we're going to talk about today is going to be the Public Records Act. As you know, we receive public records requests very often, and that can be for a wide variety of information. So what exactly is included in that? So basically any document related to what we have, like documents, papers, maps, and books, or specifically in this context, it's going to be anything that we review at the meetings. Certain licensure information is considered to be a public record. It also includes media. So if anyone were to submit paper, like for example, when we get our complaints, if you include the videos or photos with that, that's included in a public record. And then electronic data processing files and output. So when you're thinking of whether something is a public record or not, the default is it is probably a public record. Whether that information can be disclosed or not is a different question. So there are certain matters that would be excluded from public records requests, including like PII, public, the people, your personal information is not going to be included, social security numbers, but that does include like addresses and phone numbers. Those types of matters are still included in public records requests. What is not considered, dang. Oh no.
Is it turned on?
I think it doesn't like me anymore. It's okay. Oh. Okay, hold on. Okay, what is not included in a public records request? Basically, your iPads are not included. So anything that is considered as a conduit of providing that information is not going to be a public record. Your iPads, my physical computer, my physical phone, if I were to use it, is not a public record, but the information contained on it can be considered to be a public record. So that's basically public records. If anyone has any questions related to it. Okay, next we're going to talk about the Open Meetings Act. So there are 4 different types of things that we're going to talk about relating to the Open Meetings Act. First, we're going to talk about what it is, what is considered a meeting, what is required for a meeting to be covered by the Open Meetings Act, and what happens if the board were to violate the Open Meetings Act. So first, the General Assembly declared it to be the policy of the state that formation of public policies and decisions is public business and shall not be conducted in secret. So the reason that this title is "You Are My Sunshine, My Only Sunshine" is the Open Meetings Act is also called the Sunshine Law. So we want to make sure everything is done in the sunshine, in the open, and not done in the dark. So we want to make sure that we're open and transparent in the matters that we're conducting. So that's basically what the definition of Open Meetings Act is. So it does not limit any privileges and rights contained in Article 1, Section 9 of the Constitution of Tennessee. I'm not going to read that for you. So like I said before, the goal is to promote openness and accountability in the government to protect the public interest. So we interpret the Open Meetings Act pretty broadly, meaning that if we're doing anything related to board business, we're going to almost always make sure that that is done in an open or public meeting context or space. So there are very few things that would not be required to be in a public meeting format. So specifically, all meetings of the governing body are declared to be public meetings and public at all time, except provided in the Constitution. So this includes emergency meetings, any committee meetings that we may have, and of course, our board meetings. So you guys are considered a governing body, but specifically when we talk about this, a governing body consists of 2 or more members with the authority to make a decision or recommendation. So if you are talking with another board member about board business, then that ideally should be considered in a public meeting. But if you're talking about certain other matters, which we'll cover in a second, that's not always required. So anytime you're discussing matters with anyone other than yourself, that's not, or anyone other than yourself or someone else not on the board, it is required to be in an open meeting set. So this is what I stated before. Anything requiring a board business or decisions is required, and you have to have a quorum in order to make that decision and deliberate towards it. So what is not a meeting? So if anyone were to come in and make an inspection of our documents, that is not considered to be a meeting. So we oftentimes, when we're filling public records requests, we will send them to individuals either electronically or also if we send them to them physically in the mail. But there is the option also to inspect the records, which means that the person comes into the office and they look over the records here in the building, and they can take notes or anything, but they can't take the documents with them. So, but any insight inspection of any project or program related to the board is not considered a meeting. So, the inspectors cannot be deliberate towards a decision. So if I think this would also include audits or that types of matter too, if it was related to board business. So as I stated before, if you guys are meeting, if there's a chance meeting between the two of you, so I don't know, there is an East Tennessee walk day and you happen to see Commissioner Torbett and Commissioner Beckley, I know you guys would be there at the walking meeting. If you guys were to just show up and see each other, yeah, that's not going to be considered a meeting because you didn't know you were both going to be there. But if you were both going to be there and talking about board business or deliberating, that would need to be in a public meeting space. So like seeing anyone on the side of the road because I don't know any reason why, that would not be considered a meeting. But if you are deciding or deliberating board business, it is a meeting. So if two or more members of a public policy share a meal together, I know sometimes people share meals at certain boards. That's not considered a public meeting as long as we're not talking about board business during that time period. I hope Puckett's was good last night. What is not a meeting? So things like lunch breaks, restroom breaks, smoke breaks, those types of things. And when we adjourn meetings between board business day and hearing, anything in between that is not considered a board meeting. But again, during this time period, board business should not be discussed during that. So as I stated before, regular meetings, special meetings, those are all open meetings. But the exception to this would be executive session. I think most of you have been at least in one executive session. If you haven't, I'll talk more about what executive session is. So an executive session occurs when one or more of the board's members meet with the attorneys and we're under the threat of lawsuit, that type of matter, or there's a situation where we just need to speak with the attorney. So during that time period, like for example, when we reviewed our retrospective rules, that was during an executive session. Executive sessions are led by the attorneys, meaning that you can ask us questions, you don't lead those meetings. So if for example, if someone were to sue the board, then that would be the opportunity for us to tell you what's going on, how the situation works. If you have any questions related to that, you can ask us questions, but that's kind of the format of executive session. It's the attorneys talking to you, you asking questions, no decisions are made during those executive sessions. And those are not required to be public meetings. So it is not required to be filmed or open to the public at that time. But executive sessions are very rare. They do not occur often.
Anna,
Yes.
I think there was at least one occasion while I've been here where we had an emergency meeting or at least a discussion about calling an emergency meeting to suspend a license.
Yes.
Is that an executive session or is that a public meeting?
No. So what you're talking about is like summary suspension. And if we were to have a summary suspension matter, that would be noticed as a regular meeting. Any other questions? Okay, as I stated before, there's no deliberations, no decision makings that are occurring during executive session. Executive sessions are information sessions. That's what they should be viewed as. They are not anything more than that, and no board business is conducted. So how far does it go? So this one talks about a specific case that is related to the Civil Service Commission of Maury County, and it's stating that there were persons that were applying for jobs, and the interviews conducted by that commission are to be considered a public meeting. So those are required to be noticed. There would be, because if they're working within the department or areas, then that is not anything related to threat of lawsuit or another matter that would qualify for that. So while the Open Meetings Act is very broad, executive session type matters is very narrow. Okay, these are just examples of whether things are permitted or not. So if the chair were to email, here's a news article, that's fine. I'd like to include something on the next agenda, that's fine. What is absolutely not fine is, here's a news item about one of our licensees, we should consider revocation. I never want to see an email, phone call, text message that says anything like that of the sort. At that point, then we would, it would be considered to be a public meeting. So one of the reasons that we send you guys emails and information related to that blind copied is because if you were copied on the emails, that's a public meeting and that information would have to be disclosed to individuals. So that's why you won't see it. So if you're emailing us or communicating with the executive director, want to make sure that if you're talking about something that, one, there's not another board member on that meeting, on that email, and then two, it is always, if it is not something that I don't need to know, to copy me on that email. So we could have potentially, depending on the subject matter, attorney-client privilege. Okay, so if if someone were to ask me a question, I have a question about the legal consequences of something the commission has done, I can answer that question, but I have taken an action as a commissioner and now someone is upset. Y'all don't want to know. Like, let's not ever. So we know we discuss things as a body. So we can't make independent decisions on our own. So anyone in their individual capacity cannot speak on behalf of the board. You're always, if you're doing that, you're speaking in your individual capacity, but you can say you're a member of the board, but you're not speaking on behalf of the board because the board is a general body if we make that decision. So no unilateral decisions to revoke anyone's license. Thank you. So if you were to send an email or call another commissioner, that is decidedly not a chance meeting. So because you did that volitionally. So if you were to I don't even think if you accidentally had like a butt call or something, that would still not be a chance meeting really in that circumstance. But even if you don't discuss the board business, we don't really want to do that because it gives a really strong impropriety of us conducting board business. So we really want, if you guys are discussing things that are, try to do it during the meeting settings. So.
Check on you on the way home.
No, you can do that. We just can't talk about the meeting.
Right.
So, but we can discuss matters that have already been heard by the board, kind of after, just not anything that's pending.
What are you saying?
Well, I mean, I guess whatever it is, but whatever.
I know, but like I just like.
If we've met and we've
Correct.
made decisions within that meeting.
Yes.
And then at some point in the future, we talk about what we've already deliberated about. It's already part of the public record.
Right.
We're just rehashing it because we were interested in it or we were had a particular comment that we wanted to revisit with each other. Or a good job or, especially these two characters over here. But, just.
Right.
It's not, we're not deliberating a live case. We're just talking about what's already happened.
I understand, but my concern is if we're talking about things that weren't discussed during the meeting, that's my concern. So if we're having discussions about, well, I thought it should have been this or X, Y, and Z, then I think that's where we kind of get into a territory, a murky territory. So I would prefer if you have any discussions related to anything that the board conducts, that would be done at this meeting. Because my concern is whether it's like permitted or not, of course, like I said, we like to interpret it broadly because we don't want to narrow something down, then we say, actually, no, that is an issue. So my concern with that is if you guys are giving additional insight or additional deliberations. So remember, it's not just votes, it's deliberations. And so if you're talking about something behind after it's happening, it could be still considered deliberations. So I would prefer for that not to happen. If that makes sense. Okay? Good question, though. So this is the new information that I will be providing for you today. It's related to electronic attendance. So previously, it stated that in order to have a quorum for a meeting, we needed a physical quorum in the building. That is not the case anymore. During the Less is More Act that passed in July, went into effect July 1, 2025, we can have members available electronically count towards quorum. So that means if we were to be in a situation where we have 4 people here and 1 person appearing via Teams, we do have a quorum for a meeting. So that previously would not have counted, and we need to always have 5 people in the building. So with that, the issue is if we have someone appearing electronically and someone in person, then all of the votes are going to need to be conducted via roll call. And it is important during those meetings that when the persons are talking, that they make yourself clearly identifiable. So if you are speaking from the team speaker, say, this is Commissioner Smith, and I'm stating this because we want to make sure that members of the public are able to track who exactly is saying what during the meeting, and electronic attendance can be kind of confusing that way. Certain boards have the difficulties meeting quorum, and so with this specific law, hold on one second. Yes, with this specific law, it requires that each governing body meet physically present no more than once a calendar year. So we cannot have all of our meetings be electronic. We need to have at least 1 meeting here in the building. And if that were to occur, no meetings with physical presence 2 consecutive years, then we have to send a report to the Secretary of State. I don't foresee that being an issue with this particular board, but some of our boards where you have smaller amount of individuals, it is possible, but we try not to, that doesn't really happen very often. So, sorry, you had a question.
I did. So you say they must audibly say who they are as part of the electronic meeting. But do they need to have a camera on, or is that an option, camera on and off?
It doesn't state anything about specific like camera on or off option. Of course, our preference is to have your camera on so we can see you. But we can see you during the meeting doesn't necessarily mean that the public will be able to see you. So the public wasn't really, unless they were on Teams, able to see the persons on Teams because the video information is here. And we're filming this way. Teams is not the portion that's really recording it. There are 2 different options, but we're recording it from inside this room. So our preference, of course, would be to have your camera on. But if there is some reason you cannot have your camera on, but you can attend the meeting, we will take that into consideration.
Okay, so as chairman, I'm speaking often. So every
Yes.
time before I speak, I'd have to announce myself.
Yeah,
Okay,
right.
if I was
So-
remote. Okay.
Commissioner Gwen.
In your example, would a quorum be 0 people in the building and 5 electronically?
Yes.
Okay.
But we would need to have at least 1 meeting where we have 5 people available. So this would be, a useful tool if we had an emergency meeting. We would not have to require everyone to be in the building. For that, you could have a meeting via Teams. And previously, if we were to do that, we would have to file the statement of necessity with the Secretary of State's office. That would not be required in this instance.
It's all right. We just make John show up in the building.
Yes. 1 person here and 4 people online is a quorum. That's not nice, but it is a quorum.
So let's say there's a meeting in West Tennessee, and someone lives very far away in East Tennessee.
Or the meetings in Kingsport, and
And
somebody
someone
lives in
very
Memphis.
far away in Memphis. Can the faraway person choose to attend via remote?
I mean, you can choose to attend electronically, but whether you get points with your fellow commissioners and goodwill, I don't really know about that.
I doubt that's a concern.
I was just asking for a friend.
I know. It's kind of like Who Wants to Be a Millionaire? Asking for a friend. But yes, that would be possible. But again, if we were to do that, we would prefer that information be communicated beforehand so we can make sure that our technology is appropriately situated so we can make sure that everyone hears that information. And again, we would just have to do all votes via roll call and require just a little bit more attention to who is speaking at what time. Okay, as I stated before, this is just kind of a simple thing. The act is most favorably construed most favorably to the public, as with public records too. The goal is transparency and openness, and so whether a meeting or not is required to be an open meeting, it most likely is going to need to be, but for those very few circumstances.
I like the citation. Shout out to Shelby County right there. Good job, guys.
1990. Okay, this is, as we were stating before, the public has the right to attend, observe, and make comments at our meetings. So as you know, we have a portion on our agenda for public comment. So the public is allowed to make those comments, but it is generally listed to the items that are provided already on the agenda. We do construe that liberally, though. So if it's generally a matter that is within the jurisdiction of the commission and germane to the issues that we're talking about, public comment is most likely going to be permitted at that time. Excuse me. Any questions about public comment? Okay. So public notice, this is not really something that you have to be concerned about. That's something we internally really have to do. But for circumstances when we are setting meetings, there is a three-pronged test for adequate notice. So reasonably, sufficiently, and posted. So we want to make sure that, like, this is for why we set our meetings out a year in advance. There is not a specific time that has been stated what reasonable or adequate public notice is. But generally, we want to make sure that people have at least a couple of days, if possible, to know about the meeting taking place. So we don't want to say on today that we're going to have another meeting later this afternoon that we weren't noticing. I don't think that would be really considered adequate public notice in that time, in that specific instance. So the contents of that should reasonably describe the purpose of the meeting, so we can't just say we're having a meeting. And so the contents, we usually do that on the agenda to tell us individuals what we're doing and what we're going to be discussing. We don't just show up and say and surprise everyone. That's not good for anyone. Sufficiently, like I stated in advance of the actual meeting, that is more so for the public to be available to come to the meeting than it is for you, whether you're available or not. So we want to, again, make sure that the public is aware. And then notice must be posted. So we post that information on the website. And it is usually, at least for our agendas for the meetings, is usually posted it a week in advance of the meeting. So I definitely know that that qualifies as adequate public notice. But if we were to have like an emergency meeting, less time would be possible, but we don't want to make it so short amount of time that individuals aren't able to make accommodations to attend. But three usual methods, this is really funny to me, internet, newspaper, and bill posting. We use the internet. We don't use the newspaper or whatever bill posting is. We don't do that. I'm sorry.
So bill posting is basically you just type up what you're going to do and you stick it outside so people can walk by and read it.
Like on a billboard.
Like on a billboard.
Oh no, I'm showing my age. I'm so sorry.
Or I'm showing my age.
I didn't know it had like a specific name. Noted. Okay, I might remove that from the PowerPoint. Open Meetings Act, the notice, as I was stating before, the notice online is we want to tell people the location and where the meeting is going to be. And as I stated, our normal practice is to post it on the website. We look at all facts and circumstances to determine whether adequate public notice is provided. So if someone were to contest that we did not provide that, we're going to look at we're going to be looking at the three different factors: the reasonableness, necessity, and then I forget what the P stands for, but whatever. Okay, so what are the penalties of the Open Meetings Act? So there are two pretty big penalties that if we were to violate this. The first is nullity, meaning that anything that the board did during that meeting is null and void. It has no effect whatsoever. The second is that costs and attorney's fees. So if someone were to contest that we conducted a meeting that wasn't in public and that means they have to bring suit and we lose, then we would be liable for their costs and attorney fees for bringing that action towards someone. So, but the biggest thing that we want to talk about would be the nullity. So anything that would be decided at the meeting, no matter how small, would not have any effect whatsoever. So as we talked about before, we want to make sure that open meetings are provided and accessible to the public. This applies to you as an individual member and collectively as a board. We've already discussed what the meetings are. Chance meetings are something where you don't know about it in advance. If you know about it in advance, it is not a chance meeting. But all meetings include special emergency meetings, subcommittee, and committee meetings. The only exception would be executive session. And as we know, executive session is usually limited for the threat of litigation. And that is more of a information sharing session. No votes are taken and no deliberations are made. And we have to give adequate public notice for every meeting. If you violate the law, any violative acts are void and costs of litigation may be assessed against the board. As I stated before, nullity and costs and attorney's fees are the consequences. So the last thing I would like to talk to everyone about is the North Carolina Board of Dental Examiners versus the Federal Trade Commission. I know everyone remembers this case from the last time I gave this presentation and your orientation manual. So basically what happened was the board issued 47 cease and desist letters to non-dentists about teeth whitening. In response, the Federal Trade Commission stated that they had violated the antitrust laws to ordering the non-dentist individuals from providing that services. The board argued that they had state action immunity, and then ultimately the FTC prevailed at the U.S. Supreme Court and determined that the board did not have state action immunity. So they stated that one of the reasons that the board did not have action immunity defense was because they did not receive active supervision by the state when it interpreted the act that occurred and when it was enforced. So they kind of did it without anybody in the department knowing about it, or it was just not adequately supervised. Also, state agencies are not simply by their governmental character, sovereign actions, and entitled to state action immunity. That immunity, it states here, requires more than a facade of state involvement. So it ensures that we have, acceptable political accountability for anti-competitive practices. So what we're doing based in this, this whole case is about anti-competitive practices, meaning we do not want to limit practices that we do not regulate from individuals that are not licensed by us. So if it is not expressly within our statutory provisions and someone else were to do that and we were to say, no, you can't do that, that would be considered an anti-competitive practice. It is the easiest way, I think, if you were to say it colloquially, is you are out of your lane. You're not staying in your lane, and you're trying to regulate other individuals to make them have a license when they don't need one. We should call it the stay in your lanes, whatever statute. So one of the things that came from it was active state supervision. They determined that the board did not have active state supervision. So it is to make sure that whether the state's review of the mechanisms provide a realistic assurance that the actor's conduct promotes public policy instead of the party's individual interests. So we want to make sure that we are adhering to our overall mission of consumer protection. We're protecting the consumers, we're not protecting the industry. That doesn't mean that we disregard all of the industry's wants and needs, because of course we have rulemaking hearings and that type of thing, but we don't want to become protectionist of our industry, meaning that we don't want to be looking at a point of view of, oh, well, that person, we want to make sure that real estate agents have, occupy the whole field or something like that. I have a problem of explaining this with other of our boards than some of them, but you guys are pretty well understand the consumer protection industry matter better. So it's the balance of consumer protection and enforcement. So we don't want to withdraw enforcement because we don't think that someone actually really did something wrong. We need to determine whether we are actually looking towards the interests of the public. So after North Carolina Dental, we passed a statute that requires supervising officials. So within a supervising official within the statute, it can be the commissioner or chief executive person or whoever they designate. In this particular instance, for our purposes, it's going to be the policy director. So we have a policy director that reviews all of our meetings. And if this person were to see something that I, for some reason, didn't see during the meeting that they believe was a possible anti-competitive practice, they would let us know. And then if we were required to do something as a special meeting or an emergency meeting, we would take that into consideration. So yes, each supervising official shall ensure that the actions of the regulatory boards that displace competition are consistent with a clearly articulated state policy. So if we're doing something that curbs participation of non-licensees, we need to have a clearly articulated state policy behind it. We need to be able to explain why we're doing this and why this is important. So if we don't have anything other than because we think so, that's not going to work. So the supervising official, as I stated before, can make a determination either what would happen if a anti-competitive practice were to occur. So I really this would mean that they go over it and then within 10 days, we would let you know. We made this decision before, and it needs to have further discussion of what's going on. And that is probably going to take place in in a special meeting so we can decide it. And so in writing at that time, we would either approve the action, remand the action, or veto the action. So, and if for some reason the board were not to reverse the decision that was made, there is a last catch-all that the commissioner of the department has the ability to veto that decision. However, the commissioner is required to provide notification to the General Assembly if that were to occur. So we have lots of layers of protection from this to make sure that it doesn't happen. But if for some reason the board were to decide against it, then we have the ultimate veto from the commissioner. So if something were to occur in a situation, usually what happens is we'll have a discussion in the meeting about, I don't know if we can do that. I don't know I think we, for example, we talked about maybe here, or maybe it was appraisers, I can't remember, BPOs, whether those were to fall in our jurisdiction or not. Neither of the statutes in either our board or theirs discusses that. So it doesn't necessarily require a license for that type of activity. So if we were to decide that it requires a license, that would be considered like anti-competitive practice. That's the only one I can think of at the moment. But if we were to start stating things for people to have a license for matters that are not clearly articulated, then we would need to have either a well-articulated state policy that explains why we're doing it. We would need to have a statute to support it, a rule, or those types of things. But mostly, we're going to dissuade you from doing that. And it's not to be punitive or that type of matter. It's to make sure that we are staying in our lane and keeping the interests of the consumers and public in mind.
So, Anna, on a related example,
Yes.
I know I've had conversations like this, and maybe others have, about having a separate license for commercial agents that would just work in the commercial field because they feel it's a distinct enough practice from real estate, and the education is different, that maybe a separate license is required. And the response that I've been given is that there's no distinction between a license and a statute. So if there was going to be a commercial license, it would have to come from the legislature.
That's correct. So as you know, we don't have definition for residential or commercial. There are a couple statutes that are categorized in a commercial section of our statutes, but it's not that specifically. And so if we were to classify a commercial license versus a residential license, then we would need to have a statute that does that specifically. And anything beyond that. So for example, we have principal brokers, but as I was mentioning, that is something that we do with statute and rule. But if we were to create another license type or anything like that, we would have to have a statute to allow us to do that. Just like when I promulgate rules, I need to be able to have a statutory authority to support that. Generally, the board has the ability to make its own rules and regulations, but we would want to have concrete examples of where we can do that. Do you have a question? No? Okay. Well, that's it. So that's my contact information. You guys should already have it, but it's there on the board if you need it. If you have any questions, of course, you can always ask me about it. And hopefully we don't have to discuss this again until 2026. Okay.
Well, at least one more time when we get a new commissioner to replace
Well,
Ferris.
we've already kind of talked about that because I was like, Commissioner Gahn is not here. Our new commissioner is not here. And so and we were trying to decide whether we were going to do this. I did not want to do this meeting in Jackson because reasons. And I didn't want to do that, and I don't want to subject people to that. And then I didn't want it to wait until December. So whenever we have a new commission member, they do have an orientation, which is a very condensed version of this. But what I think I'm going to do is also just give them homework, and they're going to have to come back and watch this presentation and write me a short essay explaining exactly what went on. But no, I'll be citing this presentation to them so they can review it. Okay, thank you so much.
All right, commissioners, everybody still comfortable with proceeding through, or do we need a break? You want a break? Yeah. All right, let's see. All right, so we are going to go into recess for 10 minutes. Let's come back. Let's call it 10:45. Okay, it is 10:45. We are ready to come back into session, come back to order. And the next item on the agenda is the education report. Ms. Brittany, what do you got for us today?
Commissioners, I'm excited to be presenting the education report today. On pages 1 through 10, you will find the 29 candidates who have applied to be certified TREC instructors. These individuals present today have met the qualifications for instructors as listed in TREC Rule 1260-05-.04.
Commissioners, are there any instructor applicants that you would like to pull for further discussion? Here none, is there a motion to approve instructors candidates A1 through A29?
So moved.
Got a motion by Commissioner Smith, seconded by Commissioner Torpett to approve these instructor applicants, candidates A1 through A29. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Ms. Morris.
Next, on pages 11 through 19, you will find the 48 courses that providers have applied for your approval to offer continuing education credit hours to licensees. All courses presented today have met the requirements set forth by TREC Rule 1260-05-.03. I do want to call out a couple of courses, A47, A48 from D&D School of Real Estate to offer the TRACE course, both in classroom setting and paper and pencil. As stated in our last meeting, Executive Director Baker, myself, and Ms. Matlock did hold a webinar for our providers to give more information about the TRACE course. We were happy to have 40 attendees on July 9th, and that webinar is available on our webpage for further viewing if you would like to watch it. So yeah, just wanted to call those out for you.
So are these the only two applicants for the TRACE course?
As of right now.
As of right now.
Our providers technically didn't really know about the TRACE course until July 9th when we held our webinar. So this is actually quite a quick turnaround. So I'm excited that at least one provider is offering it in a couple of formats. So classroom, paper, and pencil. So that would be a distance learning.
Okay. Commissioners, is there any desire to pull other courses specifically? Hearing none, is there a motion to approve courses A1 through A46?
Motion to approve.
Got a motion to approve these courses by Commissioner Gwen, seconded by Commissioner Tucker. Any further discussion? Hearing none, all those in favor, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Ms. Morris, anything else in the education report?
Just wanted to call out that lastly on page 20, you'll find the exam snapshot for all exam types, the pass-fail rates for the month of June. Just so you know, the month of July will be included on the October report just because this report had to be turned in on July 30th. So we didn't want to give one less date. So you will be hearing about that on October. And if there's no questions, that concludes my report.
Thank you very much. Ms. Baker, your turn. Your report, please.
Good morning. On the iPads, you will see my report. I do have one action item that will need to be voted on, and then I'll have several updates for you all. Are there any questions in reference to some of the numbers that are on the report itself before I get into the updates and action items? Okay. On the iPads are proposed meeting dates for your review and action. The proposed dates are in line with other boards within TDCI by meeting every other month. This will also begin, in 2026, this will also begin the rotation of having one meeting in East or West Tennessee every other year. It's easier to provide streaming to everyone in Tennessee. When we do have the meetings here in Nashville, they are streamed across the state. Or wherever you have internet access, so it is a little bit easier. Sometimes when we are on the road and doing meetings, the streaming capability is not there. So it kind of benefits everyone in East and West or wherever you may be to attend the meetings and hear what's going on with the commission. So the dates are there for your review and approval.
Commissioners, if you've looked at the dates, remember, attendance is not compulsory. Now we have the option to attend through Teams. Is there any further discussion on the proposed meeting date schedule?
Attendance is compulsory. Like, you still have to come to the meetings. You don't have to come in person, though. It just, I just want to make sure. we don't.
But you have the latitude to miss the meeting if you need to.
Yes.
I have a question. Since we're only meeting in east or west, can the entire commission go to the Arello Annual Conference?
I was just gonna say that too.
No.
All go to Arello?
Yes.
It's only because it's in
We all can all
Miami.
go to-
If it was in Milwaukee, nobody would want to go.
No, we want to go to the
Oh, okay.
September meeting.
I understand why.
September meeting in Hawaii.
Yeah.
TDCI has a policy in reference to traveling. So we would have to get special permission to even attend this meeting. In addition to that special permission, the policy states no more than 3 commission members could possibly attend the meeting. So we are still going to have to make the necessary requests several months out in order for Tennessee to have a delegation to attend the meeting.
So we can't raise our hand now.
You all very well could. However, there are many approvals that would need to happen in order for Tennessee to send a delegation of 6. I know we're sending a delegation of 4 people to, which I will report on momentarily. But we are sending a delegation of 4 to South Florida next month, which I'll discuss in moments.
So you need us to approve the meeting?
Yes, if I could get a motion to approve and a second and a vote on that, we can post these to the website sometime this week.
Commissioners? Is there a motion to approve the calendar for 2026?
Make a motion to approve the calendar for 20. There you go.
So we have a motion by Commissioner Smith to approve the proposed meeting calendar for 2026, seconded by Commissioner Torvid. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously.
Thank you for approving the meeting dates. I have a few updates for you before I will read the public disclaimer and answer any questions that you all may have. Excuse me, Commissioner Diaz, Anna, Brittany, and I will be attending the Arello Conference next month in South Florida. Commissioner Diaz and I will be attending additional training by completing Arello's Commissioner College 102. Previously, last September, we attended Commissioners College 101, so we'll complete all of our Arello training next month. Also have a program on the Tennessee High School program. Are there any other questions in reference to the Arello Conference? As of today, yes.
Are you talking about the Arello, the upcoming one or the one you're talking about?
The one next month.
Okay, I've got a question about the next one.
Okay. The one in Kentucky?
No, the one in Maui.
Okay.
How much notice do you need to go through the channels? Like 6 months or a year
I believe the
or
policy
what?
states 90 to 120 days. I can start submitting paperwork in order to get that approved by the commissioner and our chain of command.
So I can make a motion now? Is that too early?
What's your motion?
No,
You don't need a motion.
What's your motion? Why are you making a motion?
for her to go through the steps to get it approved. It's a year in advance. Why not?
I think we were going to probably do that regardless, but first, please pay attention to what Director Baker said. We have to get approval to go in first. Like before we start drafting people to go, we have to get approval to go to Hawaii.
Correct.
Because
That's
right
what-
now,
yes.
the travel is pretty much contiguous in the United States.
I'm not saying we're naming the 3 people to
Right,
go.
yes.
I'm just saying, let's
Yeah.
get approval to send 3 people. We got a year notice, you know.
Okay.
It gets in the budget, whatever it is.
9 people. Just throw it out
She
there.
said it was limited to 3.
Yes, TDCI has a very strict,
Have you ever had this much interest in it?
never. It's usually crickets.
Y'all skipped Kentucky. There's another conference before this one. No one wants to go. Okay.
TDCI has a very strict policy in reference to travel. As our general counsel, or excuse me, our program counsel said, we have to get special permission to go because it's outside the continuous 48. And we have a conference, we have 2 conferences in between that conference, so we don't want to bypass Kentucky as well. because that's an important conference that we could all drive to, which would make it easier with flights and whatnot. I've never had y'all's attention like I do right now. But the TDCI policy literally states an attorney, an executive director, our education, well, I'm not sure if it says the education director, and no more than 3 board members. So that doesn't even guarantee us 3 board members that are able to attend the conference in September. Or us, for that matter. So, and I serve on a committee, so I'm not sure what will happen. I will do my best to try to get approvals, but I cannot guarantee it because it's not in the continuous 48.
But you do know that if 6 or 7 of us went and we wanted to share some of the money that would come, you know, it'd be a little bit.
Or we could just have a meeting there.
Unfortunately, Ms. Torbett, the state doesn't work that way, but I understand your eagerness to attend the conference next September.
It's funny how quickly fiscal conservatism flies out the door when Maui's involved.
Just imagine, hey, we're having our meeting this year in Puerto Rico.
Sure, let's get
Shouldn't have been on our paper. It should have just said around.
I'm all about truth, trust, and transparency. Truth, trust, and transparency. That's how I like to lead. If there are no more questions about Arello, I would like to move into the Tennessee High School Senior Program, Licensure Program. As of today, 155 students have taken part in the program. Out of those students, 36, about 23%, have fully completed the 60-hour Principals Core course. Principals pre-licensing course, while another 16 are about 3/4 of the way through it. For the 30-hour course for new affiliates, 17 students have finished it completely and 6 are roughly 75% done. Notably, 16 students have completed both of the pre-licensing courses. Looking at milestones, 134 students are nearly 87% have completed milestone 1, and 69 students, about 44% have completed milestone 2. Lastly, 35 students, roughly 23%, were withdrawn from the program for lack of participation in the program. Are there any questions in reference to the high school program?
Go ahead, Ms. Smith.
Yes, I have a question. Do you see that participation greater in middle or east or west, or is it spread out over the state?
I don't know. I can report that to you in October. We do have that information. I know last year it was kind of equal across the state, but we can pull that information, and I'll have additional information for you in October. Mm-hmm.
So I know the students are just making their way through the licensing program, so you don't yet have data that shows how they're being picked up by brokers?
Yes, we've had, I believe 3 to 5 people that have completely finished the program and are now active licensees within the state of Tennessee.
That's excellent. So you're not seeing any resistance from brokers?
Not at all. I haven't seen any resistance from any broker or a participant telling me that a broker will not hire them.
So in terms of publicity or media talking about the program, do you expect to highlight these applicants that have completed and are practicing, or is there?
We
or at
have
least
discussed
asking
that in
they
the
would?
past, and it is our point of view that we don't want to put one licensee above another licensee, so we're not really naming the names of those that are licensed because we don't want to appear to be biased for those people that participated in the program.
I guess I'm different. I wouldn't feel that it was a bias at all, but, you know, I don't make that decision, so.
Yes, we consulted with our communications team in-house, and so we were thinking about doing that earlier this year just to promote the program, but we decided to go in a different direction.
Quote Ms. Matlock, I'll stay in my lane.
Lastly, I have an update in reference to the October meeting location. Denny, Brittany, and the Central West Tennessee Association of Realtors have been very helpful in planning the October commission meeting that will be held at Jackson City Hall on October 16th, 2025. A day prior to the meeting, TREC, along with the state's fire marshal's office, will host a free training session that will be at Central West Tennessee Association of Realtors for any licensee in the area. Are there any questions in reference to the October meeting? I know Commissioner Tucker has a prior application and will not be able to attend. And hopefully, our new commission member will be there in October. If there are no questions, that concludes my report. And I would like to proceed with the public comment period.
Public comment period is open.
All right. The department encourages public comments in open meetings through various avenues and welcomes healthy, oh, I don't have to read that. Yes. Is there anyone wishing to speak? If there is no one wishing to speak, the public comment period is over.
Okay, public comment period is closed. Our next item on the agenda is the legal report. Do you think it'd be better to get the new business done before we do the legal report, or?
We haven't made any changes to the agenda, and I think Ariel and Kim are prepared unless, am I able to change, are
Commissioners,
we able to
what do you
change the
think?
agenda in the middle of the meeting?
We did it.
We were already in waiver request. If that's the will of the commission,
Gotta thank everybody. When we finish the legal report, they kind of like to leave right after that.
okay.
So,
We got a car started.
so if there's no objection, you want to proceed to the election of chair and vice chair? Okay. We will do that then. All right, so next item we're going to do is new business, which is the election of the chair and vice chair for the next fiscal year 26. Nominations for chair are open. Are there any nominations?
Yes, I would like to nominate Jeff Diaz for our chair for the fiscal year of 2026.
Second.
Are there any other nominations for chair? Hearing none, nominations are closed. All those in favor of the motion, please say aye.
Aye.
All any opposed? Hearing none, that motion carries on a, I'll abstain from the vote.
6-0.
6-0. Thank you. Nominations for vice chair are now open. Are there any nominations for vice chair?
I'd like to nominate Joe Begley.
So,
Can you turn on your mic? I'm sorry.
I'd like to nominate Joan Smith.
so hold on. So Commissioner Smith nominated Commissioner Bagley. He declined. And then he nominated Commissioner Smith. Commissioner Smith.
So we have a first and a second for Commissioner Smith as vice chair.
And now we're open for discussion.
Yes.
Discussion.
I would like to know if there's someone who would like to have their name in the hat. Don't jump up there so quick.
Also, I would like to clarify, we did this wrong before, but from here on out, we are not allowed to have anonymous voting.
Anonymous voting?
Like, you know, when we just put names and we read them out, we can't do that.
Last time.
Yeah,
It was 2 years ago.
or whatever.
Yes.
Right, so if we're voting on someone, we have to do it out in the public, because that would have been in the dark. We have to know who did it.
I understand.
I don't remember doing that.
Yeah, we did it one time, but I just wanted to clarify.
Meeting at the archives.
that.
Yeah.
Okay.
It was when I was hired. It's okay.
I'm sorry if I was guilty. I don't know.
So, so Joan?
Let's not rehash the past. We have a open nomination with Commissioner Smith as vice chair. We have a open nomination by Begley and a second by Moffitt.
What does the vice chair have to do?
Yeah.
preside when the chair is not there. But otherwise, not that much different than being a commissioner.
Okay. I will accept that nomination with this contingency.
I can't guarantee I'll be at every meeting. You can't do that to me.
Yes, I can.
No.
Yes, I can. That Jeff Diaz attends every meeting, and if he
discipline.
cannot physically attend, he must be on video.
Only if I could be one of the commissioners to go to Maui.
Oh, no.
Just for the record, I don't think we can allow that contingency. I do want to state that for the record, but we do have to get back, we do have, since we are on the record, we have an open nomination, and we are now discussing. And I believe the chair hopefully will call for a vote soon.
So you accepted the nomination, Ms. Smith?
I accepted that nomination, but the floor is still open
The floor is still open.
for another nomination.
Are there other nominations for vice chair? Hearing none, the floor is closed. Nominations are closed. Any further discussion on the nomination?
Sick to my stomach.
Don't be. We're
Yeah.
also here too
You can,
to help.
you could always vote no.
I don't think I can vote.
You could. You don't have to abstain
Vote for yourself.
or against. All right, we'll go ahead and vote then. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Congratulations. Then Denny, where's the vice chair plate? Let's go ahead, get it on the record.
But I think this is for fiscal year 2026.
That began in July 1. Congratulations, Vice Chair Smith.
And it was vacant because DJ stepped down.
Oh, do we already have a name?
Ann and I plan to attend every meeting.
All right, so that concludes new business. Let's go ahead and get to the legal report. Joe's burning and staring at me right now, so. All right, so the legal report was presented to us along with the rest of the board materials. All commissioners had a chance to review the narratives prepared by counsel. And commissioners have decided to pull the following cases for review. Cases 2, 6, 7, 8, 9, 10, and 11, 27, 29, 32, 37, 42, 67, 68, 73, 93, 97, and 103. Are there any other cases that commissioners wish to pull? Hearing none, is there a motion to accept council's recommendation on the remaining cases?
Make a motion. Make a motion to accept council's recommendation on all cases except those that were just named.
I have a motion to accept council's recommendation on remaining cases, seconded by Commissioner Moffett. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Aye. All right. That motion carries unanimously. Thank you, commissioners. We are going to case number 2 in my notes. I would like, the motion, council's motion, I think, was to dismiss. Yes, council's motion was to dismiss. I'd like to do a letter of instruction, just kind of to, remind them to avoid posting their, the personal history of others online. I mean, I hate that we have to say that nowadays, but I mean, don't get other people's business out there.
Okay.
Is there a motion to
If I-
issue a letter? Go ahead.
If I may, before we do that, if I could also add, or request that you add to that recommendation, that council be allowed to contact Forewarn, the app, and let them know about the misuse of the terms of service by this particular licensee.
Okay, so there's a motion to issue a letter of instruction in case number 2 and to allow council to contact the app known as Forewarn about their violation of terms of service. Is there a motion?
That is a motion.
Somebody so
Yes.
moved? The motion is made by Commissioner Smith, seconded by Commissioner Moffett. Any further discussion? Hearing none, Let's vote. All those in favor, please say aye.
Aye.
Any opposed? Hearing none. That motion is approved unanimously. Case number 6 is also mine. Case number 6, the question I wrote down was, what was the verbiage in the pitch deck? They had a pitch deck that they were using.
Correct. I thought about including the advertisement but I couldn't get it to format in the,
Right, because the contention is that they are practicing without a license for unlicensed activity.
that they are advertising in such a way that someone looking at it would assume that they are a licensee.
Okay. It's a small detail. I'd just like to hear.
Yes, sir. This was a rather lengthy pitch deck, so let me get to the correct page. I just passed it. Where'd it go? There it is. The firm is a descriptive real estate brokerage representing a portfolio across the world, including in Tennessee. The firm's in-state presence is led by respondent, who has brought in nearly, and they name a figure of sales during their tenure greater than any team in the market that this was posted to.
Okay, so triggering the charge of unlicensed activities, the real estate brokerage language?
Yes, sir.
Okay.
That's what I felt. Obviously, if the commission deals differently, I'll.
Mm-hmm. Okay. I don't have a problem with council's recommendation. Is there a motion?
I make a motion to accept council's recommendation on number 6.
Commissioner Smith makes a motion to accept council's recommendation on case number 6, seconded by Commissioner Torbett. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 7 was discuss. Is there anything you want us to know, Ms. Cooper, about this case?
Yes, members of the commission, 7, 8, 9, 10, and 11 are all related cases. They are all against a principal broker. 7, 8, 9, and 10 are somewhat muddied in the sense that they more involve commission disputes, but also allegations that funds have been stolen from the affiliates. In each of those cases, the respondent did not respond. So there's at least the violation that they did not respond. But also, actually, I think it was number 10, I apologize. 7, 8, and 9 could be considered commission disputes with a failure to respond. Number 10 was an earnest money that was not returned. So failure to.
Okay, but the target, the respondent for the complaint didn't respond at all.
But they didn't respond to
any
that
of
one
the-
either.
Through 7 through 11?
Correct.
None of them?
And then the 11 is the firm that this respondent is the principal broker for. So we have 5 different complaints essentially with the same individual. My concern is that this is sort of spiraling out of control, and so that's why I throw it to you all for discussion. I didn't want to just end with the failure to
understand.
respond.
Kind of a question. On that one, do you know if the check was ever made good, or is it still out for insufficient funds, or is this a as of yesterday comment?
As of the time I submitted this legal report, it had not been made good.
Okay, thank you.
Yes, ma'am.
So it seems like there are at least 5 incidents of failure to report, failure to respond. And we have authority up to $1,000 per charge. Ms. Matlock usually doesn't like us to do a per incident civil penalty, but it seems like it's warranted in this case. Commissioners, what's your pleasure?
It seems like we have a lot of violations to consider here. The easiest would be failure to respond on all 5, on all 5 of those.
Yeah, I think it would be hard for us to render a decision on the other charges that are made because we don't have a response. So I think,
I've got a question.
go ahead, Commissioner Gwynn.
Are all of the 7, 8, and 9 license or different people? for the same
Yes,
thing?
we have 3 different licensees. Yes, sir.
Could we do failure to respond and also litigation monitoring? Or if you do failure to respond, that's it till you get a response?
What I would suggest in order to have some sort of deadline for this respondent is make the recommendation for a civil penalty for failure to respond, and then direct counsel to monitor the criminal investigation that's running parallel with this situation. And I can then report back at some point if maybe to recommend administratively opening a complaint based on newer information or something along those lines.
And there's a deadline when we submit the letter, when we send the letter saying this is the findings, and this money is due by a certain time. Is that correct?
So a consent order, once it's sent out, they have 30 days to respond, to either
Okay.
accept the consent order or say that they don't want to, that they want to litigate the matter.
Right.
And then we move forward at that point.
Okay, if they say, I accept consent order, then is there a period of time from that consent until funds are actually submitted to?
They have to do it as soon as possible. I mean, once they say, yes, I'm accepting the consent order, then they're expected to comply. You need to
Like
send it
within
back.
30 days?
Yes, ma'am.
My concern would be that there are a multitude of violations, and if we just give a failure to respond civil penalty, that might be the easiest out, is they'll pay the fine for failure to
Right.
respond, and then what happens?
Yeah.
Right.
I agree.
What was the day they signed for that certified mail?
In which case, sir?
7?
Or 7?
Well, all of them were 24, weren't they? Consent, or are you talking about the E&O insurance?
No, that they got notified by certified mail, and it shows that they received it.
There it is.
Why is the sheriff involved in 9 and not 7 and 8?
From what I can tell, only the licensee and / complainant number 9 was the one that took it to that next level and is alleging theft.
And my concern too, following up Commissioner Torres, is the return check.
Right. The complaint was received February 21st in that case. It was sent out to the respondent by email and certified mail on Wednesday, February 26th. And it was the signed certified receipt. He didn't date it, or they didn't date it, but it was received back in our office on April 7th.
So it's been a while.
Yes.
I suppose
They did sign for that one, but then as things went on,
they stopped signing for it.
apparently the jig was up and they quit signing for it, yeah.
So we also have the option to defer and wait for more complete information if we wanted to on these cases, or put it into litigation monitoring without assessing a penalty now.
You could take action on perhaps 7, 8, and 9 for failure to respond, litigation monitoring on number 10. In the meantime, I could also try to do some additional investigation and get some more information regarding whether or not to move forward with another recommendation, either suspension, revocation, or dismiss if we get new information.
If we suspend, what is the process for reinstatement?
Well, I believe they probably wouldn't accept that consent order if they want to continue practicing real estate, but they may. But if they don't accept the consent order, then that would trigger a formal hearing, I would think.
Yes, sir.
And then they would have to appear before us, and that would be a 2-day meeting.
So can we assess a civil penalty and also suspend their license?
Yeah, we can.
You can
I
take
just-
action on each individual
I
complaint
just
however you feel.
don't like the fact that there's quite a bit of money involved and absolutely no response, and then the response, I guess, in the one is the money's gone, there's no money. I have bills of my own and the office still has to pay its bills. I cannot pay you your money if the money isn't there. Screams a lot of red flags to me, which is why I would consider suspension.
Yes. Any recommendation that you make that involves a consent order, they have that 30 days to respond.
So even if you recommend a suspending of license, they've got 30 days to say yes or no, or I'm out of business, or come back in, correct?
Yes, ma'am.
So can I make a motion combining all of those, or do we need to make a motion for each one separately? 7, 8, 9, 10, 11?
I believe as long as your motion is specific, that it said that you're including complaint numbers in 7, 8, 9, 10, and 11, I can combine them all in a consent order and just list the complaint numbers and say this is the recommendation of the commission.
And you can do that in one motion.
Yes,
Okay,
ma'am.
I'll make a motion and we can discuss. But I'll make a motion on 7, 8, 9, 10, 11, that we assess the civil penalty of $1,000 for each instance of failure to respond and suspend their license.
So I got a motion by Commissioner Torbett to assess a $1,000 civil penalty for cases number 7, 8, 9, 10, and 11 for a total of $5,000 civil penalty, and to suspend the license of this licensee. And that would-
I'm sorry, to be clear, 7, 8, 9, and 10 are against the broker. 11 is against the firm they are the principal broker of. So it would be a 4,000 and a 1,000 on each respective respondent.
Okay,
That's
so,
fine with me as long as that's clear on your end.
Oh,
so
yes,
to
I'll-
restate,
Would it be suspending the license of
Suspend
the
for how
firm
long?
and the broker?
if that's your motion.
well, if,
Counsel,
if,
how long can you suspend? Like, is this suspension,
so the,
how do you
the,
reinstate it once it's been suspended, I guess is my question. What would they have to?
Commissioner Gahn turn off his mic, I'm sorry.
So if the person's license is suspended, my understanding is we just put the terms on require reinstatement into the consent order, unless it would be outside of what is required for renewal. So their license would be set to suspended. We usually put, in order for your license to be reinstated, you have to do X, Y, Z.
is there a term of amount of time you want to suspend the license? I think we have to say
Yes,
that
it
too.
just can't be suspended. We need a time period.
Suspended for 1 year.
Okay, so to restate the motion, Commissioner Torbett, for cases number 7, 8, 9, and 10, we're going to assess a civil penalty of $1,000 per for failure to respond. Case number 11, we're going to assign a civil penalty of $1,000 for against the firm license,
How much was that?
$1,000. And then we're also going to issue a 1-year suspension to the respondent for all these cases. 7, 8, 9, and 10. And that's seconded by Commissioner Moffett.
7, 8, 9, 10, 11, correct?
All, yes, they're in the motion. Is that good for you?
Yes, sir.
Okay. Commissioners, any further discussion?
Question,
Commissioner Gwynn?
why are we suspending the license?
It sounds
What's-
like they've kept money they've kept escrow money, they've not paid commissions. Seems to me like there's commingling of funds if they're taking money from
But,
one
I don't
fund to
know
pay
that-
office bills.
I don't know that we have evidence. I mean, to me, the earnest money, we've got, the person that didn't get the earnest money back is not complaining, it's the broker. So,
But once that consent order is received, then they can come forward with more information.
It was the agent for the buyer who lost their earnest money that filed the complaint.
the agent lost the money?
No, sir. It was the agent for the buyer. The buyer paid their earnest money. The deal fell through. They agreed to a
Right.
mutual release. They agreed to return the earnest money, the respondent did, and then the check bounced.
Right.
Yes, sir.
So the person that the check was written to is not complaining, it's their broker, correct or wrong? Their agent.
Yes, technically, yes. I guess on their behalf, but yes.
Let me ask you, didn't they send back one of the certified documents?
They sent back the first one
Right.
that was filed, but as the next 4 came in, they did not respond. And I think at least one of them was actually refused and was returned.
Right. I think we need to get his attention.
So, do we do audits in person?
We, we perform desk audits. It's all, they send in their information, and we review it. However, we can send you an investigator to the physical location if needed to collect the items that we do audit.
Is that a surprise audit if we send someone in person?
We're on the record. So if they're watching.
Surprise!
Can we go into executive session?
No.
We were just kidding.
Y'all are not funny.
So if the broker made the check good after this happened, then they have
That's
a.
what I just asked for. And the check.
No, I know what you asked her.
Yeah.
So I'm just saying that we're suspending a license basically to get somebody's attention is what it boils down to. Because,
Well, I would disagree. I mean, it is to get their attention because they're not responding to
Well,
their
that's-
licensing board, but
that's
it's
the response.
it's also to, I would say, indicate that this is a grievous offense here of not managing money correctly. I don't know how else y'all
Right.
would define that, but to me, it seems like more than just oops, the check bounced.
So, Ms. Baker, do we know, other than the affiliates that have been on the record for complaints, how many affiliates are in this brokerage?
I let me look that up. I neglected to look that up.
Because I'm worried about suspending the license would cast those affiliates.
Well, remember, they have 30 days to
Adrift.
respond, so it's not as if we suspend it today and they're suspended. There's still a
Right.
process, so.
Yeah, but I don't think they're getting together for beers and saying, hey, man, my license has been suspended. Y'all need to
Let me look that up.
change your circumstances here. So,
And I would be surprised if some of the agents haven't already done that.
yeah, so.
I would say if they're operating in good faith and they don't agree with this, they can come here and explain the situation.
There are about 5 affiliate licensees.
So they would have the 30 days waiting for him to respond to the consent decree or not.
I mean, their license isn't suspended. It's my understanding their license isn't suspended immediately.
Right.
They still have 30 days to respond or sign the consent order or, I mean,
Right.
yes. But there are 5 licensees associated with this firm.
And then the affiliates would have some time after that 30 days. Like if,
I was just gonna say, whenever it is determined that that license is suspended, the affiliates at that time would have 30 days. So it could be in 30 days or a little bit longer, but yes, after the license is suspended.
so can I amend Commissioner Torbett's to add the secret the surprise audit, an investigator. To ask for an audit and an investigator. We can ask for the audit from the desktop like we typically would, and then send an investigator.
Okay, we wouldn't necessarily have to send the investigator if they were to comply with the audit and forward us the documents that would be required.
Perfect.
Okay, all right. We will add them to our audit schedule for the month of September.
So somebody, can I second that?
Or actually, I'll request that she sends the audit information now, yeah. Yes, we're gonna,
Okay. All right, so again, just to restate the amended motion, we're going to do $4,000 for failure to respond on cases 7, 8, 9, and 10. $1,000 against the firm for failure to respond. We're going to suspend this respondent's license for 1 year, and then we are going to put them on the audit schedule for September.
they will be placed on the audit schedule once we finish our paperwork. They'll be placed on the audit schedule,
Okay,
yes.
but they are going to be scheduled for an audit
Yes,
at the desktop.
yes.
Everybody good with that? Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 27. So on this one, there seems to be a disconnect between when they decided to walk away from the purchase and sale agreement. They thought that the purchase and sale agreement had been terminated. It seems like it was done verbally outside of a standard form that exists in TR. For reference, it's RF 481, mutual release. So I'd like to, rather than dismiss, I'd like to do a letter of instruction to the respondent to avail himself of standard forms from the Tennessee Realtors, better document his transactions and avoid confusion. Is there a motion to that effect?
I'll make a motion that we send a letter of instruction to the respondent for number 27.
Second.
Motion by Commissioner Smith to send a letter of instruction to case number 27, seconded by Commissioner Torbett. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 29.
That's you.
That is me. I know, I'm just. So I guess my question here is that it seems like the principal broker for this respondent hadn't, am I looking at the right case? Hadn't spoken to their respondent in over a year? I mean,
That's what the
so,
principal broker who responded said, yes, sir.
so the licensee is expired active. What does that mean, expired active?
I believe this respondent has active E&O insurance.
Yeah, that's what it means.
Yeah,
Okay, so it's an expired license, but he has active E&O?
correct.
Okay. So you got the failure to respond on there. I was thinking in over a year. I mean, there's no broker release, none of that?
Let me check. I know that they sent it to the principal broker's address because that was also the address that was the most recent address for the affiliate. And I had made the recommendation for unlicensed activity, not failure to respond.
Okay.
No, apparently a release was not filed because as of right now, I'm looking in core and it says that they still are related
Okay.
to that firm.
So when I read this case, I felt the need to add failure to respond as another infraction. But I'd also thought, maybe an admin complaint against the principal broker for failure to supervise. I mean, he hasn't seen this guy in a year. No broker release. And this guy's out here.
But he's still listed under that original firm? His name is still listed there? Is that what you just said?
They're still listed, but their license is showing expired. Yes, sir. Or yes, ma'am.
That's okay.
I mean, that's what I felt when I saw it. But right now, counsel's recommendation, as she said, was civil penalty for unlicensed activity. Any further discussion or motion?
I'll make a motion to add failure to respond.
Okay. So the motion is to accept counsel's recommendation and add to it a $1,000 civil penalty for failure to respond. Is there a second?
Second. 2 seconds.
Motion by Commissioner Gwynn, seconded by Commissioner Tucker. Any further discussion? And no thoughts about the administrative complaint against the principal broker for failure to supervise?
Sure, we'll add that.
All right. Commissioner Bagley, is that acceptable, Commissioner Gwynn?
It is.
Okay, so to restate the motion is to accept counsel's recommendation for a civil penalty of unlicensed activity at $1,000, add failure to respond for another $1,000, and to administratively open a complaint against the principal broker for failure to supervise. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 32, that's me again. This one, my only question is close and flag. I guess I'm just wondering what you're hoping to accomplish that. Is that just in case he resurfaces or this respondent resurfaces? We can,
Both that and the complainant is still in the ongoing process of trying to get their certificate of occupancy and is in discussion with legal counsel regarding some remedies they might want to avail themselves of, which I completely understand. And so depending on the outcome of that situation, it might be reasonable to reopen the complaint.
okay. Is there a motion to accept counsel's recommendation?
I make a motion that we accept council's recommendation on number 32.
Is there a second? Second. I have a motion by Commissioner Smith to accept counsel's recommendation to close and flag on case number 32, seconded by Commissioner Tucker. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 37 is a discuss. Ms. Cooper, what would you like us to know about case number 37?
So as the summary explains, the audit was opened. There was no response to the audit. Their license expired, I believe, right after. Oh, no, I'm sorry. The license expired while the audit was pending and has since been closed. And they still have not responded to the complaint. In addition to that, they still have 8 affiliates that are tied to the firm in core, but all of those affiliates are have either been expired for a year or more. One is deceased. So my concern is that, and there's no principal broker for this firm. They are now affiliated. They're a principal broker of another firm. It sounds like they just left it and decided that they didn't need to contact the commission with any information about any of that. So that's why I throw it to you all.
Wow, this was an administratively open complaint, so this is this a result of the not responding to the audit and then it was administratively opened?
Yes, sir.
Okay.
I pulled this also. So what are our options on this one? My first one was civil penalty for no response. But now you're telling me other information.
I don't think the firm is active anymore. I don't know that there's anybody to pay a civil penalty if you assessed a civil penalty. However, the principal broker that was the principal broker at the time that the firm closed is now a principal broker of another firm. And so it might be a good idea or reasonable, I should say, to open an administrative complaint against that principal broker for failure to follow through and communicate with the commission regarding the termination of the firm and the release of these affiliates, and to do the most basic paperwork that they're required to do when they're winding down a firm.
And this person is now the principal broker at another firm, is that what you're saying?
Yes, ma'am.
My gut's telling me we need some education.
Well, we do have that trace course.
You would need to recommend first that a complaint be opened against that principal broker. Here, we just have the complaint against the ghost firm
Okay.
that didn't respond because apparently they're not open.
Okay, so I'm going to make a motion that we open a complaint against that principal broker who is now principal broker at another firm, and that's on number 37.
Is there a second? So a motion by Commissioner Smith to administratively open a complaint against the respondent in case number 37, seconded by Commissioner Torbett. Any further discussion? Hearing,
If you could also recommend that we close this complaint.
Okay.
Yes, sir.
Is that a different motion?
we can make it one.
It can be part of the same.
You good with that? Okay.
Good with that.
So the motion again is to close case number 37 and administratively open a complaint against the respondent in case number 37 for recharging them for failure to respond.
It's the principal broker of the respondent, right, that we're opening the complaint against?
Correct.
Yes.
I thought the principal broker is the respondent.
No, it's a firm.
It's the ghost firm.
It's the ghost
that they
firm.
just let.
So the broker wouldn't have, possibly didn't get the complaint.
I know.
It's a different firm.
Okay, so,
Did he do a release when he left and went to the new firm?
They did a transfer and then didn't release any of the,
Affiliates
and didn't
below.
notify the commission about the status of any of the affiliates that were still affiliated with or related to this firm.
Which he wouldn't have to if he just transferred. If a broker transfers firms, and do you know when he transferred firms?
It looks like October of 2023.
Yeah, I mean, he did it 3 years before any of this stuff's even on the radar. This stuff didn't come up till April of 25. Am I right? Or am I looking at 37?
you are.
Yeah, so I mean, that broker has nothing to do with 2 years later with that firm. I mean, they should have got a new broker in 23, but they didn't, I presume.
And they also did not notify within 10 days of the firm not having a principal broker.
Yeah, but the broker's running the firm, aren't they?
That broker left 2 years.
No, sir. They left and went to a different firm and are now the principal broker of a new firm. They apparently just decided to open a new firm.
It happened during the time of the audit, if I'm understanding correctly. Is that correct? During the audit, that's when they transferred to the new firm?
No, they transferred 2 years before. And because they never notified the commission about any of this, including that the affiliates were still affiliated with this closed firm or inactive firm, the audit was opened. And then because nobody responded to the audit, then a complaint was opened for failure to respond.
So can you tell if the firm, the ghost firm, is that a single brokerage or is it a part of a larger corporation that has several
Is it a franchise?
franchise? Yes. Thank you.
I think it was a franchise, but let me double check.
What we can do also is send a 10-day letter to those still affiliated with the firm without a broker, and to close that firm if they don't have a principal broker in place within 10 days.
Just to clear my head, so in 23, this firm that we're looking at, that their license expired in June of 25, which is a month or two ago. 2 years ago, a broker left and went to a new firm.
Yes.
So,
And those other agents left also.
Some,
Who knows?
who knows, because they're still affiliated with this firm.
Yes.
Even though their license may be expired.
So if I looked online and saw that name, John Smith or whatever, affiliated with that firm, would it show up affiliated with another firm also, or is it still tied just to that ABC company?
As far as what I could tell, they're still just tied to this one firm,
Okay.
the respondent.
So according to the state records, these agents, these realtors or agents, are still tied to that firm and not showing up where they have moved, or if they have moved.
If they have moved,
And they haven't had a broker in 2 years.
right.
But that's
Well-
not the broker's fault.
She did say some of the licenses are expired, and in one case, a licensee is deceased, so. Did you see if they were part of a franchise or a single?
Based on then what I can just see on this one page, and Ms. Baker knows Core better than I do, she may be able to find it. It looks like it's a franchise, sorry, is the word I'm looking for.
So it wouldn't necessarily be a departed principal broker's responsibility to find a new principal broker for that firm. Right. It would be whoever operates the franchise. Right, Joe? Is that what you think?
So, I mean,
Is that
that's
how
the
the
way I
franchises
understand it.
work?
If I leave my firm today, that firm and those affiliates are not my responsibility tomorrow
As a franchise?
unless they come with me.
Right.
Even as if I don't own the firm, if you own the firm and I leave your firm today and go manage Kathy's firm, a month from now, you and those affiliates aren't my responsibility.
Right.
So whatever happened to that firm or those affiliates, I've moved on and I'm running this firm.
Okay. Ms. Cooper, did he file the paperwork? I mean, I guess he filed the paperwork to be a broker at another firm.
Yes, in Core, they are now the principal broker of another firm.
But he didn't, but that form doesn't let you walk away from the other firm, does it?
Honestly, I don't know.
This appears to be an internal mishap. This happened it appears October of 2023, so right after I started. All the licensees affiliated with this firm, no one has a current license at all. All the licenses are expired. The firm no longer has an active license. It expired on June 3rd of this year. In addition to that, we wouldn't necessarily need to send a 10-day letter, but I'll work with counsel to close the firm internally because they no longer have a firm license.
Okay, so if this broker left in '23, I mean, what triggered the audit? Did it just come up randomly?
Yes, so all audits we use a randomizer to do all audits.
So, and because it was listed as an active firm still, it came up?
Correct. And as of June 3rd, it was an active firm. It just expired June 3rd of this year.
It just didn't have a PB.
Just didn't have a principal broker.
So the randomizer will still choose the firm because it's still active, and it could very well have been active in 2023 because the license is good for 2 years. So the randomizer picks that firm, and then we discover the firm is no longer open, so we can close this firm because.
And there was nobody there to respond to say, hey, we're not doing any business anymore.
Correct.
In
They
20
should have closed the firm properly. It did not happen.
We weren't even doing audits in '23.
No, sir. However, if you're active in our system, it will pull the firm because
Right.
June of '23, sometime then is when they renewed their firm license, and it's good for 2 years. They just did not close their firm properly.
So in the case, I'm asking commissioners now or council if they know, in the case of a franchise, is it the franchise operator's responsibility to shut down the firm?
No.
Or is it the PB?
It's the PB.
But they didn't have to shut it down.
Unless they turned the lights off in '23 when they walked out.
We don't know when the firm officially closed. Yeah.
Do we have a motion on the table?
I would point
We
out
do.
that Rule 1260-02-.38 does put the responsibility on the principal broker to notify the commission within 10 days of the resignation, termination, or incapacity of a principal broker. That was not done here by the principal broker.
I thought you said he did leave in 23.
They did leave, they did not notify anyone, which is why 2 years later, we're here.
You said they filed the transfer.
They filed the transfer, but does that not trigger something regarding the firm? Not at
It
all?
should
Okay.
internally, but not, it didn't trigger it at the time. Now we have rules in place that we look for a PB before we transfer a PB. And that wasn't being done in October of '23, right when I started, and before we started doing audits. If you recall, we didn't start doing audits until March of '24.
So if I fill out a track one
If you,
transfer, I can't transfer till you find a new PB.
we hope to have the same applications at the same time. So if you were a PB and you were to say you're transferring to this, we would look for a new application from another PB to put that one in place before transferring you to the new firm, to ensure that there isn't a firm without a principal broker. That's the internal process that we now have in place.
Which is a good process, but if a firm's struggling, that's why I'm leaving, because an owner situation, there's,
Mhm.
aging out, whatever. I'm hostage at this place until you find somebody else.
Not necessarily. What we will then do is issue a 10-day letter, and that firm has 10 days to have a PB submitted to us. But we are actively looking for it now, and in October of 2023, we were not.
The-
We do have a motion. We can,
Correct motion.
it may not be.
Can you restate the motion?
I don't know. I'm not sure I can.
That's why I asked.
So the motion is to close case number 37 as it is right now, and to administratively open a complaint against the former principal broker, now principal broker someplace else, for failure to respond.
Did I make that motion?
No, sir. And I apologize to Commissioner Begley. I'm just, this whole situation irritates me because the rule does require not just notification, but they also must submit a plan that addresses the continuation of operations, which I would read into that also should address the fact that we're not going to continue operations. I am leaving this firm as the principal broker. I'm transferring. Hey, this firm is going to close. The transfer was submitted, but nothing else was submitted. So now 2 years later, everybody's wasting their time trying to figure out what's going, like I said, I'm irritated, I'm sorry. What's going on with this defunct firm. And as the principal broker, I feel like there should have been some responsibility on this person to let the commission know that not only are they transferring, but everybody that's there is nobody left there because we're closing the firm, and that was not done.
I don't know. I've been a principal broker, and I'd hate to have that on my shoulders if it's a franchise, and I don't know, if it's a franchise. I don't know if they're gonna continue or not. It's not my firm. So, I mean, I'm supposed to, so then if I write in and say, hey, this firm's going to pieces and it's awful, then they're gonna say, I'm making up stories about them. They're good and thriving firm. So, I mean, I've done my part. I failed out of track one. I've said I'm transferring. If I need to stay or help them, during the 10-day period or whatever the case is. But as far as me telling you how this firm's going to continue for the next 2 years, I can't tell you that. I mean, they may get some superstar broker in there and have 30 agents in 18 months. I have no idea. I just know I'm leaving. And, I mean, as long as I haven't done anything, we're just going to vote. Let's
I'm just saying
vote.
that the rule requires a plan be submitted at the time of the notification. That's all that I can advise you all of.
Shall we take a look at the statute to further, so we all can have further clarity on it before you all motion, or excuse me, vote on this motion? Would that be beneficial? It is 1260, what is it,
1260-02-.38. 1260. They have the page number. I just have
I am
the
looking for
computer.
that page number right now, one moment. It is on page 90. In the middle of the page. Is everyone on page 90?
It's a death or extended absence of a principal broker? Is that
Yes.
where you're at? And which paragraph? One?
Yes.
So I would think that part of discussing the plan to be submitted about the continuation of operations would be whether or not the firm was going to remain open or not.
I guess the plan would need to have been submitted in 2023. However, we didn't have the practices that we have in place now where we're checking for a new PB.
But the statute, the rule was there though, right?
I have a question.
The rule was there in 2023, yes.
I have a question about that. The way I'm looking at it, it doesn't seem to specify who must notify the commission. It says the commission must be notified within 10 days of the death, resignation, termination, or incapacity of a principal broker. But does that mean that the firm must notify the commission, or does it mean that the leaving principal broker, because if they died, they can't notify the commission, so who bears the responsibility for that notification?
Currently, when a broker is deceased, we receive notice, and sometimes they have a principal broker in place. Sometimes I do number 2, which is on this list, and give a 30-day extension to that firm for someone within the firm or whomever to take their principal broker exam. That has happened during my tenure here. So 1 and 2, I have seen happen on several occasions.
But my question is, whose responsibility is it to notify the commission?
If someone is deceased, usually someone in the firm notifies us that the principal broker is deceased, and then we issue a 10-day letter.
But I'm not talking about just deceased. I'm
Okay.
saying in general, for that rule or statute or whatever it is, it says the commission must be notified. Whose responsibility is it to notify the commission? Because what we're hearing here is this broker that left
We will take notification from anyone.
should have notified.
Or we have taken notification from anyone, including the principal broker that is leaving because of, for
But if he
differences
didn't,
with the owner.
So if he didn't,
Okay.
if he didn't notify that he was leaving, I don't feel like it's his the way that's written, the firm should be responsible. Who's responsible? That's a little unclear to me, honestly.
Well, so the way the system's set up, there's a track 1 form.
Mm-hmm.
So when he I know you're pointing at Steve. So there's a track 1 form, and you're saying that you're going to either retire your license or you're going to transfer or whatever. That triggers this whole thing. So now they've got this back end system to say, hey, whoa, Joe left, so now who's over here running this place? Which
Yes.
is great.
And
So
if
it's
we
kind
don't
of a
have that,
redundant
we issue a
check
10-day
system.
letter.
Yeah.
And send that to all the licensees associated with that firm, letting them know if they don't have a plan in place within 10 days, we're closing that firm.
Yeah.
But we didn't have that.
Not in October of '23. I was less than 60 days in. So that was not in place then. It is now.
So the motion is to close case number 27 against the firm. 37. And then administratively open a complaint against the former principal broker of this firm, who is now at another firm, for,
Who made that motion?
I don't remember.
Keep going, Joe.
Joan made the motion.
I think I made them.
Yeah, Joan made the motion and Mr. Boffett seconded.
I believe
Okay.
so.
Close case number 37, and administratively open a complaint against the principal broker of this now defunct firm, who's now at a new firm, for failure to respond. Is that the charge, or violation of Rule 1260-02, 38, paragraph 1,
It would be for the rule violation.
for the rule violation? So that's the current motion.
Let me ask the question, what was the rule back in '23?
The same rule applied, however, Trek wasn't looking at that as intently as we are now when a principal broker leaves a firm.
So
back
ignore
then,
anything about the internal processes. The rule itself was still in place. What Director Baker is saying that now how it operates, when we receive that notification, there's an automatic trigger that someone needs to let us know that the principal broker left. At that time, there was nothing, but the rule was still the same rule. Does that help?
Yes.
So he could come back and say,
Well, let's not speculate on how he's going to respond. That's not our lane.
that's what we're citing him for, is
Right.
failure
Well,
to
but
submit a.
let's not speculate on how he's going to respond, though. That's up to him. I think, at the very least, a complaint would ascertain the facts a little bit clearer than what we have now. I mean, and it could be that council comes back after new information and they say dismiss because they're satisfied with the response. But the point is that we don't know, and a rule was violated. So we had to decide how do we enforce this rule on him or not?
But I'm still not convinced the rule was violated.
All right. Somebody want to call the question, or we want to keep talking?
Question.
Question has been called. It's not debatable. Let's all vote. Everybody clear on the motion? Good. All those in favor of the motion, please say aye. All opposed?
No.
Appears the noes have it. Floor is open for a motion.
I make a motion to dismiss.
Ms. Dorban made a motion to dismiss, seconded by Commissioner Moffett. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
I do have one thing.
Commissioner Bradley, go ahead.
So, you're still sending a letter about.
I'll review it internally to see if a letter needs to be sent, but the firm is now expired. So it's not something that we would renew with our current processes without a principal broker. I don't believe so, but I'll defer to program counsel.
All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 42. That's mine. All right, so in that one, I was wondering about the phrase program closing the complaint. I don't know what that means. Was it complaint? Did I say that right?
That's how the respondent put it, so I don't think that the respondent understood what that meant either. There was, the audit was technically finished and/or closed because there was a finding that they didn't comply. And so they got a letter that, like I said, apparently confused them, saying there's been findings, this complaint, or this audit has now been closed. And so I think they latched onto that closed part of it and thought that, oh, well, I don't have to do anything now. And so they've never complied with the audit. They haven't submitted anything to the auditor. So the audit is still, it was closed because they didn't get any information, not because there was no findings.
Oh, so they got a letter from us that said, what was the finding? The finding was that they didn't respond?
That they didn't comply with the audit as required by,
So they said later in that letter somewhere that the complaint was closed?
that's what the respondent, well, in the letter, yes, it does say that we are closing this because you're not complying, you're not providing us with anything, we can't move forward with the audit for your records because we don't have any records. And so we're closing the audit, but we're opening a complaint for failure to comply with the audit.
I see, and that's later on in the letter.
And so that's, yes, and so that's what we have here.
So they probably stopped reading when they saw closed.
It happens more often than you think, yes, sir.
Okay. So council's recommendation is to assess a $1,000 civil penalty for failure to comply with an audit. And, okay. That's the council's recommendation. Is there a motion?
I make a motion to accept council's recommendation on number 42. Second.
Motion by Commissioner Smith to accept council's recommendation in case number 42, seconded by Commissioner Torbitt. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 67 and 68 are related.
Yes, they're related.
Did we get out of Ms. Cooper's? Ms. Cooper's out of the seat?
Yes, it's my turn now.
I'm gonna count to 10 and then,
All right. Let me get there. All right. What should we know about case number 67, 68? Ms. Carter?
Yes, so I guess, quickest summary I can give. The two respondents essentially were on a team. The respondent in number 67, I guess, went to a seminar of some kind and discovered like, this brand new kind of way of marketing to kind of get new, I guess, leads for like buying or selling property. And I guess the language that they used, the respondent in 68 kind of just took it and sent this very, very bare bones letter. Essentially, it was just like 2 sentences. Their first name, I don't think they even had their last name. They didn't include their license number and like that. So it was very weird to kind of receive it whenever there was a complainant's.
So was it just a general mailing that just went out to a subdivision, or?
It was like targeted. I think their issue was that they said that there was a buyer interested in the property, and they're saying that that wasn't correct. It was misleading. The one in 67 was just part of the team and doesn't believe that they should be liable since they're not the ones who sent out the letter or responsible for supervising that individual. And that's why I made the recommendation to dismiss on 67, and then for 68, it was the actual affiliate who sent out the letter with no kind of information about, that would indicate that they are a real estate professional.
Okay. So, but you said that on the mailing, the firm was identified and the firm phone number was there as well?
For number 68?
For either of them? 60.
Number 67 didn't send anything. They were just part of the team. They're just the one who like brought an idea to the team and was like, we should do this for marketing. And number 68 was like, I'll send this off. And they didn't like get any approval from their principal broker before they sent out the letter. But their letter did not include anything of use. It just included like their first name,
All right.
but nothing to indicate they're a real estate agent.
All right, so your recommendation was to dismiss in case number 67?
Yes.
And in case number 68, you want to assess a $250 civil penalty for failing to include required information and administratively open a complaint against the principal broker for not supervising?
Correct,
Failure to
yes.
supervise? Is there a motion for cases number 67 and 68?
Make a motion, we accept council's recommendations for number 67 and 68.
Is there a second? Second. Motion is to accept council's recommendation in case number 67 and 68, seconded by Commissioner Torbett. All those, any further discussion? All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 73. All right, so this one, I didn't have a problem with council's recommendation on this one, but I also wanted to add education. My notes said core course, but I don't know. I'm open, maybe assessing different education. Commissioners, what do you think? And council's recommendation is to assess a civil penalty of $1,000 for unlicensed activity in violation of statute and open again complaint against the principal broker for employing an unlicensed individual. Commissioners, what do you think?
Just a minute, I'm reading,
You reading?
I'm reading.
Okay.
So what education are you suggesting?
I was suggesting a core course, but now that I know that 30 hours might be a little heavy, but
I keep making the motion, somebody else needs to do this.
well, you're the vice chair now, so.
While y'all are thinking about that, I have a question for council. What does it mean that they subsequently filed a lawsuit to stop the future sale?
So essentially, when they realized that their property was listed still, they weren't like entertaining the letter of intent to purchase. They believed I'm assuming that they assumed that they had like some kind of binding agreement with that letter of intent that they were going to sign, but it wasn't official yet. They're just kind of negotiating it. And so in civil court, they went ahead and tried to do like what's called a stay, which is like just kind of stopping all kind of action until they can kind of figure out what's happening, because their assertion would be that they're entitled to purchase that property.
Got it. Okay. I'm going to make a motion that we accept council's recommendation on number 73, but add education to be included and suggest the core class with no hourly credit toward their 2-year licensing period.
You want to give them the 6 months, 180 days?
Within 6 months of date of acceptance of the consent order.
Okay, so the motion is to accept council's recommendation in case number 73, but to add education, a requirement that the respondent take the core course to be completed within 180 days, and for that not to count towards their continuing education. Is there a second? Seconded by Commissioner Tucker. Any further discussion? Hearing none, let's vote. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 93, Commissioner Smith.
Yes, that was me. And this is where there was a discussion and the agent made a comment about the home inspector. And in this one, council recommends this respondent be assessed a letter of warning to ensure that they exercise reasonable skill and care by clearly and explicitly providing their clients with all information. Although that wasn't in bold writing to catch our attention, I make a motion that we do send a letter of warning.
The motion in case number 93 is to send a letter of warning to this respondent for
Providing skill and care.
for failure to provide reasonable skill and care.
Right.
Seconded by Commissioner Moffett. Any further discussion? Hearing none, let's vote. All those in favor, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 97, Commissioner Smith.
97 was me, and this is where the complainant purchased a home and then found that there was a sewer easement on it. So my question was, were you able to see a copy of the legal description on that property? I'm just wondering if there was a sewer easement in the legal description.
Neither party included that. I didn't ask for any additional information, but based off what I've read, the respondent I don't think would have even tried to pull it because they weren't aware of it, and they said that their client was unaware of the easement issue. So,
Okay.
but I can always ask additional information if they have it.
I guess my concern was sometimes we miss those things. And so I guess my next thought would be if I'm a buyer and I saw that in my legal description, then obviously that would catch my attention. So that's why I was asking if there was a copy of a legal description or deed or anything that was provided at the same time that showed the legal description with that easement in it.
Nothing was provided at the, with the
Okay.
response or anything like that, and the complainant didn't have anything.
Okay.
They just kind of realized it afterwards. But if you would like that information, or at least me to ask, I can do that. I can defer this to the next one and ask for that information.
Was the complainant represented?
Yes.
I would like to hear some other commissioners' opinion. Or a vote.
I'll see how the buyer could not look at their title policy.
You don't get that a lot of times.
You don't get it at closing?
Until closing,
Not
yeah.
until closing.
Well, they didn't have to close. If they don't want the easement, don't close.
Yeah, but they didn't know the easement was there.
Well, they do it at closing.
I mean, it sounds to me like that's not something that was disclosed at all, even at closing. seems to me like if it was disclosed at closing, then there might have been a different result, but
Right, I agree. It's a, residential is completely different than
Yeah.
commercial. Yeah, but you don't get that title policy until you're right at closing, and then they're sliding those papers over so
And you
quick.
don't have to sign the papers.
But
look
if you
at
don't see it, you don't know it.
yeah, not,
Sign something you don't
not,
see.
the people that sign things every day that they don't read,
Yes.
they just sign.
Yeah.
They just
You need to
sign.
come, you need to come to one of my closings. Welcome to my world. I'm gonna make a motion that we accept council's recommendation.
Second.
Commissioner Smith offers a motion to accept council's recommendation in case number 97, seconded by Commissioner Tucker. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 103. This is Commissioner Smith.
Yeah, that was me again. Hold on just a second.
Another audit issue.
It's an audit issue, and my note says was a letter sent, but I'm trying to figure out where the letter was, why I made that note.
A letter sent telling you about the audit.
About the first audit, yes.
Okay.
Issue letter related to. Okay, I'm gonna go with council's recommendation. I make a motion, we accept council's recommendation on 103.
Motion by Commissioner Smith to accept council's recommendation in case number 103, seconded by Commissioner Moffett. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. If there's nothing else, council, I believe that concludes the legal report. Staff, anything else?
The next meeting will be held on October 16th, 2025, at Jackson City Hall in the George A. Smith Meeting Room at 101 East Main Street in Jackson, Tennessee, 38301, at 8:30 a.m.
Very different one, it's a better one.
Thank you, Ms. Baker. All business.
Do we know if that's a one-day meeting or two? Did she just say?
I think it's a one.
Do you know if one-day meeting or two?
We will know in September.
So you still.
You are staying at a different hotel.
Yay.
I hope.
Which will we not stay on, we will not state on the record.
That's right.
She said the 16th.
If there be no business, we are adjourned until October. Safe travels, everybody.